Someone make it make sense.
Probably a couple.
Hello, everybody. Okay, let me make sure I'm sharing things to you guys. Okay. Get my windows all set up. We got a lot going on tonight, that is for sure. I'm excited to be here with y'all. Hopefully you can hear me and everything. Let me just make sure my audio is here. Okay, cool. So, yeah. So, yes, indeed. All right. So first thing, let's just start off with the latest here out of Idaho. And so it's nothing too earth-shattering, but what I wanted to do is just go over this real quick here because I do think it's interesting. So this hearing already happened, right? Now, I knew that there was a closed hearing. I remember that but the thing that I wanted to point out is this, because this is significant. This hearing that happened on December 11th was a defendant's for ex parte motions. And for anyone who's not familiar with ex parte, it means without the prosecution. Boy, I wonder what that could possibly be about, right? Very interesting. So counsel for the defendant is going to present oral argument and testimony. And that's all we got, but it was ex parte. So then we have this coming out of that hearing. So there was another supplemental request for discovery from the defense, right? Nothing to write home about there. It's just your standard languaging. But stipulated motion to seal states supplemental response to request for discovery, like I just mentioned, regarding expert testimony. So they're citing ICAR, that we've seen this a billion times. The state respectfully requests that the court seal from public disclosures states supplemental response to request for discovery regarding expert testimony and all attached exhibits herein. So, I mean, I would have to imagine this probably has something to do with the IGG. But again, this is coming out of that closed hearing. So that's the latest. I just double checked and there was nothing else new since this. So that's the latest. So the next thing I wanted to show you guys is something that is interesting. So when I was doing timestamps from the last live stream, I noticed something interesting, as I often do when I'm doing timestamps, which is this. Let me see here. Okay, so as it relates to the AT&T warrants, right? So we were reading over these, we were going through this last time, and I noticed that as I was reading this, I read it as it was printed, and it wasn't until I was doing the timestamps I noticed something really funny. On December 23rd, 2023, Corporal Payne of the Moscow Police Department requested a warrant. So December 23rd, 2023. And I was like, wait, what? Like, that's like almost a year after the arrest, right? Like what? Because we know he was, arrested on December 29th, 2022, right? Homicides were November 13th, 2022. I was like, wait, hang on. So I noticed it because I was typing up the timestamps and I always put the dates, and I was like typing 2022. And then I heard myself read this verbatim and I was like, 2023. And I thought maybe I read it wrong. And then I looked and I was like, wait, what? So then I cross-checked it with this one, which is the first AT&T warrant, right? Because we know there were two of them on the same day. They were just like hours apart. And I looked at this one for the first warrant, and it says the same thing. December 23rd, 2023. Now, what's interesting here is here it says they were looking for information regarding his phone's whereabouts between November 12th, 2023 and November 14th, 2023. Now, if we go back to this one, phone's whereabouts from November 12th, 2022 and November 4th. So it's like they got the year right here, right? As far as the November 12th to 14th, but they got the year wrong here. And then on this one, they got the year wrong here and here. And I was like, wait, am I confused? Like, what is going on here? So then I cross-checked it again with this. I was like, there's no way, but just to make sure, right? Because I'm like, how could they possibly get that wrong? So this was filed back in February 28th of 2023, okay? And this includes like all of the AT&T related things up to that point. And so sure enough, right, these documents that were from back at the beginning of 2023 include all the AT&T warrants, right? Like, I think it even says, where is it on here? At some point, it actually says, find it here. Look. On December 12th, 2022, Brett Payne obtained a search warrant for AT&T. The warrant was served on December 23rd, 2022. And then here's this email that we've heard reference of. All of this, December 23rd, 2022. So they got the defense got the year wrong. They typed 2023 instead of 2022 in those motions to suppress. And I haven't heard anybody say anything about it. But anyway, I just wanted to point that out in case anybody was confused, because that seems like a crazy thing to get wrong, or, you know, I typo, mistake, whatever, but like really, like, anyway, it threw me off when I was doing the timestamps, and I wanted to make sure I pointed it out in case anybody who's watching on replay or at the time was like 2023. Yeah, there you go. It should have been 2022. So that is one thing. Okay. So I also wanted to ask you guys, and I may ask this again later, can anyone place the quote that's in the thumbnail for this episode? The quote says, and it's in quotations, it's in this Squangwin's speech bubble, and it says, there's a lot of issues in this case. Can anybody place that quote? It's not me. It's quoting somebody else. Place that quote. Okay, so next, let me look at I've got a whole list here. So next, what we're going to do. All right, buckle up, guys. So we're going to take a look. Okay. The motion for protective order. So here's what spurred this on. I know we've looked at this a lot, but there's reasons why, right? So the talk of the FBI, like, this is really important, right? Because remember, you know, the prosecution has said like they relied on the FBI. The FBI did the family tree, they did the IGG, right? And then like what was the timeline? Months, if not a year after the fact, right? Since the arrest, maybe longer. I can't even remember at this point. But you know, finally, after much discussion and many hearings and all this, trying to get the discovery, they finally came out and said in this motion for protective order that it was the FBI deleted all their work, right? Deleted all the shit off their computer. Actually, we can double check. So this was filed on June 16th, 2023. So not a year, but many months. You know, I will say, I've noticed from watching some other people on LawTube that recently they've had some issues as well, not just me, with the spinny wheel on YouTube and also the spinny wheel on StreamYard. And I thought it was interesting that there seems to be a spinning wheel, especially worse issue going on. Anyway, so, okay. So here's what spurred this on. Let me share this to you guys. So, you know, there's obviously a lot of reasons to have questions about the involvement of the FBI, because even the way Bill Thompson describes their involvement doesn't match with what we know how that whole process works. We talked about that on the last live stream. And so when I was going through some of these documents again, back from, beginning of 2023, I saw this. So this is the Coeur, I'm going to butcher this pronunciation, Coeur d'Alene Police Department Forensic Lab. And I was like, what's this about now? So of course they're having things sealed, normal, right? Order, sealing, search warrant, and related documents. Okay. And this is in the matter. All these are attached to the same filing. So again, sealed. Again, there's nothing informational there. Okay, that's all it is. So, but what it is, so I was like, So this, I did some research. This is the Idaho State Police Forensics Lab, okay? Now, why am I bringing this up? Because this would be where they likely sent the DNA on the knife sheath. Okay, now let me go back to this. Oh, not this one. Sorry, wrong thing. Okay, so check it out. If we go back to the motion to protect order, right? What does Bill Thompson say? So law enforcement found the DNA of a potential suspect at the crime scene, and the FBI submitted the DNA to one or more publicly available genetic genealogy services. The FBI then used common genealogical techniques to develop a family tree linking the defendant. Again, they wouldn't be even, this is, again, just my point. They wouldn't be the ones doing that. We heard that yesterday from reviewing Gabriela Vargas's testimony. They don't build the tree. That's not how this works. But let's go to the part. All right, here we go. See? All right. So the Idaho State Police Lab in Meridian, Idaho, located DNA on the K-bar sheath. The ISP laboratory determined the DNA came from a single source. Now, in case you're wondering, that Coeur d'Alene, they've got 3 different locations, and I believe one of them is in Meridian. So the laboratory determined the DNA. So let me just make sure I'm clear. Bill Thompson is saying that at the very least, the Idaho State Police Lab extracted the DNA and I believe sequenced it to determine that it was male. Now, this is important, right? Because they're saying what all they did at Idaho State Police. Once law enforcement had single source DNA from the K-bar knife sheath, they conducted what is called a short tandem repeat STR analysis. They did, Idaho State Police. STR DNA analysis involves blah, blah, blah. Law enforcement submitted the STR DNA profile to CODIS. Unable to find a match using STR DNA analysis, law enforcement decided to use IGG. Then explains what it is. What's missing in here is when they gave anything to the FBI, right? Because so far, what they're saying is Idaho State Police has been working with this, right? Now it just says once law enforcement had determined, but again, this is still referencing Idaho State Police. Law enforcement submitted it to CODIS. Again, that would have been the Idaho State Police. Unable to find a match, law enforcement decided to use da-da. Now it doesn't say, so we gave it to the FBI. It doesn't say that, right? Again, it's giving more information. I'm just looking here to see when do they mention the FBI getting this sample. Family trees, again, it's just going on about family trees. In this case, investigators, okay, it's not saying FBI, right? Used IGG to begin the process of developing a lead. Now, again, here it says the Idaho State Police utilized a private laboratory to develop a SNP profile from the DNA on the K-bar knife sheath. The private laboratory started using genetic genealogy to develop a family tree. But after law enforcement decided the FBI would take over, the private laboratory ceased its efforts and sent the SNAP profile to the FBI. The private laboratory There's a lot of questions here, and we're going to get into all of it. And now it's saying, so now apparently the FBI is involved. The FBI uploaded the Snap profile to one or more publicly available genealogy, blah, blah, blah. Okay. So they went to work building the trees. Again, none of that is what they do. That would be people that they bring in to do that. The investigative genetic genealogists. Again, it keeps saying they've built a family tree. They don't do any of that. They also consulted subscription-based databases available to law enforcement. Prior to, again, it's going back in time now. Prior to the FBI's IGG efforts, the ISP laboratory developed the traditional STR DNA profile. And there's a footnote 3. Oh yeah, that's useless. So, okay. So let's just review this. So the ISP lab determined that DNA came from a single source. They conducted what is called an STR analysis. Ran it through CODIS. Unable to find a match using STR analysis, they decided to use IGG. This makes it sound like they started trying to do this on their own. Like, this is wild, right? Law enforcement decided to use IGG. Like, okay. So then, and it even mentions things like Ancestry.com or 23andMe, right? It's just going, it feels like it's just giving a lot of repeated filler here. And anyway, about family trees. And so then in this case, now back to what matters. In this case, investigators used IGG to begin. So this is like trying to suggest that the Idaho State Police tried to use IGG, like they know how to do that. To begin the process of developing a lead to the individual, they utilized a private laboratory to develop an S&P profile. The private laboratory started using genetic genealogy to develop a family tree. So now this is the second people. So from what he's saying, it sounds like they're saying the ISP first started to try to use IGG in developing family tree. But then, and it doesn't say why, then they got a private laboratory involved. And the private laboratory started to use genetic genealogy to develop a family tree. But then after law enforcement decided the FBI would take over, they ceased their efforts and sent it. This is the part that's weird because lots of things. And now the FBI gets involved, quote unquote. But again, a lot of this doesn't make sense as to what we know is supposed to be going on. And so again, this would be the lab, I believe, the forensics labs that would have been dealing with this DNA. Now, here's what also is interesting. So this is from January 11th of 2024. So remember the IGG hearing with the people, as I've been calling it, right? Gabriela Vargas, we watched this, I think it was yesterday. So that was on August 18th of 2023. So this is just, a couple months later. So public order for disclosure. So take a look at this. So, they had the in-camera review, right? Addressed the state's motion to prevent the disclosure of the IGG information and the defense's motion to compel discovery of all information pertaining to the IGG. On November 30th, 2023, the state submitted to the court in camera all IGG information pertaining to the state's investigation from both the FBI and a private laboratory. So when it says private laboratory, that can't be ISP. So there's a private laboratory involved. Okay. So that takes us next to Othram. So let me pull up this one, unshare, reshare. All right. So did some digging. So this apparently now, I mean, I don't know. This apparently was found by Kevin Fixler of the Idaho Statesman. You guys probably know that name, Kevin Fixler. Apparently he was able to dig this up, okay? So this is an invoice due December 29th, 2022. So okay, I'm just thinking. So it doesn't have a date as to when they got. Okay, so here's what it says. Rush FGGS S&P panel, $5,000. Now here's what's interesting. Idaho State Police contract. Right here. $4,500. So what's this for then? Because if you rush the panel, right, the FGGS S&P panel, you rush the panel and then you do a contract, that to me sounds like you're going to have them do more work going forward. And in order to be maybe, what's the right word? Discreet about it, right? Like instead of listing the specific services, the contract potentially between ISP and Othram would outline what they were being enlisted to, or contracted to do. But as far as the billing, they can just call it a contract, right? Now, the other thing is this. So this is an authorized price list from Othram. So remember, we saw $5,000 for the Rush FGGS S&P, and then $4,500 for a contract with Idaho State Police. I mean, one thing is that none of these are round numbers, right? Anyway, but so a Rush FGGS, that would probably be this, right? And then there that is $5,025.19. And then what you can't see on here, like, I mean, there's nothing that looks like what they have for the contract. Like, in other words, what is the contract, right? So if you look at like, custom databasing, maybe the rapid familial testing, it's just interesting. Because the thing I was thinking is like, okay, so, you know, with the DNA, there's like extraction, then there's like sequencing, and then there's like IGG is like after all that, right? And so the thing is that Othram as a lab can do it can do, like, I did some research, so they can do the extraction. Obviously they can do the sequencing and everything after. But my thought was like, who did what, right? And where did the FBI supposedly get involved? And so basically, going back to this, let's Let's see. So the thing I take issue with is that the way that they get, like, this whole thing about the FBI getting involved doesn't really make a lot of sense. And we're going to read some articles on this as well. And then the other thing is that, again, I keep mentioning how the way they describe the FBI building family tree, none of that is what they do. That's done by the investigative genealogist. The FBI is not that, right? And then Bill Thompson states that several times. And then there was another document we covered at one of these live streams where he actually walks that back. And I pointed it out in the live stream. And then he goes back to the FBI building a tree. So that's confusing. And then you've got the whole thing about how they deleted all their shit, right? Like, this is insane. Like, the FBI, here's the thing. The FBI does not need to be involved to do IGG. The FBI does not do IGG. Like, this is why it's really, like, look at this. Prior to the FBI's IGG efforts, it's like it's like they're trying to say that the FBI did the IGG instead of anybody else. For example, again, like an investigative genealogist, like, this doesn't make any sense because they don't do it. And the fact that they just poof delete things, it makes it hard to prove it one way or the other, right? And this, again, is going back in time. Prior to the FBI's IGG efforts, the ISP laboratory developed the traditional. I just don't understand why. This is just really weird. Jumping around in time. The FBI just doesn't do any of this, though. This right here, by the way, if this is the accurate, sounds exactly like what we heard described from Gabriela Vargas with the loophole, where they can get the list of people that opt out. That's what this looks like, right? Where you can, like, get the top cousin or whatever she gave an example of, and then you look at their top matches, then you do the loophole by putting in the number associated with the suspect's DNA, and then that's what that looks like. The FBI then sent, literally what he's describing is exactly what Gabriela Vargas was describing, that the investigative like, remember what she said? We listened to this yesterday. They send the tip to the law enforcement. So, for example, she would be, or someone like her would be the one sending the tip to the FBI or other law enforcement. That's why all this is weird. The FBI then sent the tip. It's like almost they're trying to use FBI in place of who actually did this. It's just very odd. Okay, so we may come back to this document, but next let me move on to the DOJ guidelines. So, all right, this is the next plan of action here. Okay, so one of the thoughts that I had was, if law enforcement, right? If law enforcement uses one of these loopholes and backdoors it and gets people that opt out and all that, right? If they use one of these loopholes, is it illegal? Or is it just a violation of the terms of service? So we're going to take a look at this. This is the only thing that really exists at this juncture in time as for the rules. And so we're going to see what it says. Moreover, the department must handle information data derived from FGGS in accordance with that. Now, here's the other important thing. This document right here does not apply to state law enforcement agencies. However, this would apply to the FBI. This would apply to the FBI, but does not apply to state law enforcement agencies. Okay, So that's why they keep saying it's like the Wild West, the new frontier. States have to have their own rules when it comes to, or laws, which they don't yet. Apparently only, what was it, Maryland and Montana are the only states to have anything yet with laws regarding the use of IGG. Which is where it gets tricky. All right. So, okay. So, right. They have to, in accordance with applicable laws, regulations, policies, procedures. Again, I just want to reiterate, this is if you're like the FBI, or maybe some other like national, right, department. So Department of Justice, as used in this interim policy, the term forensic genetic genealogical DNA analysis and searching, or FGGS, means the forensic genetic genealogical DNA analysis of a forensic or reference sample of biological material by a vendor laboratory to develop an FGG profile and the subsequent search of that profile in a publicly available open data personal genomics database or a direct-to-consumer genetic genealogy service. Here, contractors. Any criminal investigation in which the department employees or contractors conduct genealogical research on leads generated through the use of FGGS, or any federal agency or any unit of state, local, or tribal government that receives grant award funding from the department that is used to conduct FGG or FGGS. And there's a footnote here. And this is because they're setting it up in case this happens. Like, to my knowledge, this has still not been happening yet because again, that hearing with like all the people, right, was only in August of 2023, and they're the ones doing the IGG for law enforcement. So, okay, CODIS. Due to predicted levels. Department laboratories currently do not analyze SNPs during forensic DNA casework. Thus, in appropriate cases, it is necessary to outsource biological material to vendor laboratories that perform FGG. Vendor laboratories. And this is the footnote there. Contracts with vendor laboratories for FGG services should be reviewed by legal counsel to ensure that they contain appropriate language requiring maintenance of privacy and security controls for handling biological samples, FGG profiles, and other information and data, both submitted to and generated by those vendor laboratories. Again, even here, the term FGG profile means a SNP-based genetic profile generated from a forensic or reference sample by a vendor laboratory for the purpose of conducting FGGS. Again, all of this is saying that the FBI does not have the ability to do any of this, right? Okay. So after a forensic or reference sample is genotyped to a vendor laboratory, the resulting FGG profile is entered into one or more publicly available open data personal genomics databases or direct-to-consumer genetic genealogy services. We already read that footnote, collectively referred to herein as GG services. The FGG profile is then compared by automation against the genetic profiles of individuals who have voluntarily submitted their biological samples or entered their genetic profiles into these GG services. A computer algorithm is used, It is important to note that personal genetic information is not transferred, retrieved, downloaded, or retained by GG service users, including law enforcement, during the automated search and comparison process. In addition, the investigative use of FGGS involves different DNA technologies, markers, algorithms, and databases from those used by CODIS. Limitations. If the search of an FGG profile results in one or more genetic associations, the GG service typically generates and provides the service user. Again, all of this is third party. Like the lab is third party, the private lab is third party, which is, again, that actually is consistent with the language read in the motion for protective order, right? Where it gets weird is when Bill Thompson, involves the FBI, because that doesn't make any sense. Because everything on here is talking about third parties. Like, for example, right, the FBI, because this is from the DOJ, the FBI could enlist a third party to perform these services, right? But what doesn't happen is other law enforcement enlists the FBI to perform these services, because they don't do it. That's what we are seeing. That's very clear. I mean, unless Bill Thompson or the state or whatever, right? Unless they, well, because again, it sounded like they were at the beginning process of doing that. Remember, that's why it's so weird. It's like they had already had someone start working on it, private lab, right? But then they're like, I mean, the way it said, like, no, we changed our mind. We're going to get the FBI involved and have them take over and have them do it. It's like, okay, the FBI would do exactly the same thing, which is they would get a private lab, a third party to do it. But one has to wonder if by getting the FBI involved, there's a plausible deniability that they delete their shit and that's not our fault. We can't do anything about it. It's not our rules. We have no access to it. That's their process. They delete the stuff. So, like, we don't have anything to say, right? I mean, I don't know. I'm just trying to think of why, like, I don't know. It's just weird. Like, there's no, okay, let me give an example. Like, when it comes to search warrants, right? We've talked about this a little bit on this channel, how the standard that the FBI uses for the the search and seizure, right? They have the lowest threshold for probable cause. So, like, for example, when you've got law enforcement agencies that get the FBI involved only initially in the early stages of an investigation, just while they're getting search warrants, and then kick them out promptly, right? It can be because the bar is so much lower, because, again, state constitutions, they can add to the U.S. Constitution and they can add more rules and make it more restrictive, but they can't take it away. So when it comes to these rules for search and seizure and probable cause, the broadest and lowest standards are when you're dealing with the FBI. So they can come in and get a search warrant quicker and easier, right? Versus, again, Idaho, as they say in their own document, has a unique, in that they put it in quotes, right? A unique attitude towards protecting the privacy of its citizens, Idahoans. So if you go with this idea of, like, getting the FBI involved just to use them for this, like, thing, and then, whatever, one could say, is that something similar here, where they just, like, say they're getting the FBI involved, or they get the FBI involved, but the FBI does exactly what the state was already doing. But now there's this third, when you involve the FBI, now everything that comes out of this goes through the filter of whatever the FBI's rules are. And the FBI's rules are we delete our work or whatever it is, Although, having said that, again, they're not the ones doing the work. They would just be outsourcing it. But it puts them in between. We would be putting them in between the state and whatever the results are that are generated by a third party, whoever's working on the IGG. It would put the FBI in between that, to where now it's like, well, it is what it is. Does that make any sense? I mean, that would be the only. So again, it's almost like a formality. Like, did the FBI actually do anything? They're like, no, right? But now you get to apply those rules potentially. Okay. A genetic association means that the donor of the forensic or reference sample may be related to service user. However, information derived from genetic associations is used by law enforcement only as an investigative lead. A suspect shall not be race arrested. Sorry. Case criteria. It has to be a certain type of crime. So they have to have already used CODIS. They've already said that here. Investigative collaboration. They're just talking about CODIS again here. Advise the agency after consulting with the designated laboratory official. So the investigative agency shall advise the prosecutor of the nature and status of the investigation, the results of the DLO's evaluation, and the candidate forensic sample, and any reasonable scientific alternatives. After discussing these issues and based on the information provided, the prosecutor and investigative agency must agree that the candidate forensic sample is suitable for FGG. I was going to read. Okay, so this footnote. So reasonable investigative leads are credible case-specific facts, information, or circumstances that lead a reasonably cautious investigator to believe that their pursuit would have a fair probability of identifying a suspect. As used in this interim policy, the term prosecutor refers, as applicable, to the assistant attorney general, U.S. attorney, state or local prosecuting attorney, or state attorney general with jurisdiction of either the crime under investigation or the location where remains are found. So in other words, state prosecutors need to follow the rules outlined in terms of how they report this stuff, right? Like they have to try CODIS first and all that other stuff, and then talk to the DLO, which is the designated laboratory official, which is somebody from CODIS. Okay, investigative caution. Investigative agencies shall identify themselves as law enforcement to GG services and enter and search FGG profiles only in those GG services that provide explicit notice to their service users and public law that law enforcement may use their service sites to investigate crimes or identify unidentified human remains. The investigative agency shall, if possible, configure service site user settings that control access to FGG profile data and associated account information in a manner that will prevent. Now, what's interesting is we know, right, that they don't always do this, that they can actually come in and pretend they're just a regular consumer. In certain cases, the genetic association of an FGG profile with a GG service user in conjunction with subsequent genealogy research may identify one or more third parties who may have a closer kinship to the donor of the forensic sample than the associated GG user. Wow, they can actually try to get DNA from that person. That's wild. Wow. If that determination is made, the investigative agency shall consult with and receive approval from the prosecutor before covertly collecting any reference samples that will be used for FGGS. So that would be like dad trash. Covert collection shall be conducted in a lawful manner. Well, that's also questionable in this case. In addition, a search warrant shall be obtained by the investigative agency before a vendor laboratory conducts FGG analysis. Again, because they don't do it. They don't do it. They don't do it. Investigative agencies shall use biological samples and FGG profiles only for law enforcement identification purposes and shall take all reasonable and necessary steps and precautions. Biological samples and FGG profiles shall not be used by investigative agencies, vendor laboratories, GG services, or others to determine the sample donor's genetic predisposition for disease. Okay, well, whatever. Right here. So if the suspect is arrested and charged with a criminal offense after an FGG profile has been entered into one or more DTC services, the investigative agency shall make a prompt formal request that all FGG services and associated account information and data held by any such service be removed from its records and provided directly to the investigative agency. If a suspect is arrested and charged with a criminal offense after an FGG profile has been entered into an open data personal genomics DNA database, the investigative agency, so same thing, remove all that stuff. The investigative agency shall document the removal of this information and data. It shall be retained by the investigative agency for potential use during prosecution and subsequent. Now, that's the part that the defense cited in their motion regarding this. Like, in other words, this is the thing. They're supposed to remove it from the databases, right? So that, in other words, public, regular consumer people can't come across it, right? But they're supposed to retain it. So that would include the FBI. They're supposed to remove it from the freaking databases, right? But you retain it for potential use during prosecution and subsequent judicial proceedings. So what happened was, what the prosecution did was they cited the parts where it says delete it, but they left out the part where it says you delete it from the databases, but you retain it for future use for obvious fucking reasons, right? Oh my God. So just there's a lot of problems here, right? Because again, looking at the motion for protective order, the FBI does not do IGG. They would, if they're involved, they would be using a third-party vendor, which is what state was already doing, according to the motion for a protective order. But second of all, if they were involved, they would be following this protocol, which says you delete it from the ship, but then you keep it. You keep it saved up for the prosecution. And then you turn it over to the investigative agency. Like, if I were in the FBI, I would be livid at that motion. I'd be like, hey, now, don't blame us for, I don't know. And none of it makes any sense. Reference samples obtained from third parties for FGGS. Now, this is the part, you're right, shall be destroyed. Now, that means, like I read earlier, if they obtain a sample from a third party. So, for example, I think dad trash would be in this category, right? But like, if they find a close relative and they show up at their door like, hey, can we get your DNA so we can try to build this family tree better? And they're like, okay, like, yeah, you're supposed to get rid of that after. But that, again, is different. Reference sample, right? Samples, that's a DNA sample. That doesn't mean how you did it, how you built it, all that bullshit. It means a DNA sample from a third party who's not involved in a crime, like dad trash situation, or again, like I just described. So again, this is one of those things that I think the prosecution tried to reference, but they're completely misrepresenting it, and they probably left out the word reference sample, if I had to guess. Ugh. And again, if it doesn't, they destroy it. So because you can't have, yeah, if you're just a regular third party that is not involved in the crime and you're just helping out. I think that's pretty much that's that. So this is just frustrating, right, people? Hello, everybody. I haven't even been looking at the chat. They can, but that's against policy. Right. No, they don't. They don't have their own team. They don't. That's not. No. It's just, if you guys knew how many hours I've spent researching this to prepare for this live stream, I know some of you guys just got here and you probably missed a lot of stuff, but this is from the DOJ. Okay. So the FBI would be following everything I've just been reading for, like, I don't know, however long. Everything in here, I pointed it out a bazillion times. Everything in here talks about they use a third-party vendor to do IGG. The only time the FBI is mentioned here, but that's in regards to CODIS, okay? Everything else, again, I pointed that out a bunch of times. I mean, here, like, just pick a random sentence, right? Department laboratories currently do not analyze SNPs during forensic DNA casework. Thus, in appropriate cases, it is necessary to outsource biological material to vendor laboratories that perform FGG. Now, FGG is synonymous with IGG, okay? They don't do it. They have to outsource it. Oh my God. FGG is IGG. It's just when you're involving law enforcement, okay? After a forensic sample is genomic vendor laboratory, then it can be entered into these databases. But again, all of this, again, I just read all over all this. Everything is a third-party vendor. So, okay, well, I'm not a lawyer, but thank you, though. I do a lot of research, but I'm not a lawyer. Right. Again, I know you guys, some of you guys are just getting here. I already read over. So they are quoting what I already read tonight, which is the motion for protective order, where the motion for, well, we'll pull it back up. Why not? We'll pull it back up. Let's just do that. We'll just pull it right on back up. Okay. Let me unshare, reshare. Okay. So yes, that's what it says here. I mean, I've been going on and on about this. They say, I just read all this, but the ISP lab initially has it, right? Okay. Then they run it through CODIS, no match. Then in this case, investigators used IGG to begin the process of developing a lead. The Idaho State Police utilized a private laboratory to develop an S&P profile from the DNA on the knife sheath. The private laboratory started using genetic genealogy to develop a family tree. So this already, let's just break this down again. Idaho State Police, and again, I already pulled up that where that was located at the lab earlier, and then they develop an S&P profile, and then they start developing a family tree. Although, again, there's literally nothing that indicates that they do that. Like, again, law enforcement agencies don't have these abilities to do this yet. They reach out to people. We heard all this testimony yesterday. But after law enforcement decided the FBI would take over, so in other words, they've got a private laboratory already developing a family tree. But after law enforcement decided the FBI would take over, the private laboratory ceased its efforts and sent the S&P profile to the FBI. So anybody that's quoting this is quoting it from this, and this is what it says, okay? Yes, that's what this says. The FBI uploaded the profile to one or more publicly available. Now, I went over this already tonight, but everything that's in here is incorrect about how this process works. We already know the FBI, none of this is true. They don't build family trees. They don't. They outsource it. We heard this from the testimony, from the DNA hearing, but we also read it in the DOJ Interim Policy thing. So the FBI would outsource it. So like I said earlier tonight, before maybe some of you guys got here, if they contacted the FBI would literally reach out to a third party the same exact way the Idaho State Police had already done. And why the fuck? Okay, so you've got people already working on it, right? They're already working on a family tree. They're already doing all this, right? But then they cease their efforts because the FBI is going to take over. Now, again, here's where it gets, this is just not accurate because the FBI does not do any of this. And like I said before, well, you guys can go back and listen to it. I'm not going to explain all that again because there could be a reason potentially why you would want to be able to have the plausible deniability of saying the FBI got involved, right? Because it would be distancing the Idaho State Police from the third-party vendor and anything that results of that. Because then you have this thing of like, oh, well, it's not ours. We can't turn over the discovery, or oh, we don't make the rules. It's whatever the FBI does, and it's whatever their policy is, right? And it's like I mentioned already tonight. Like it's very similar to what you see in terms of obtaining these search warrants when the Idaho State Police was already also doing that, but because the standards for probable cause are much lower for the FBI. It's like just using them for a certain thing, right? Anyway, you guys can listen to that, like I explained it earlier. But so I mean, it even says right here, the FBI consulted subscription-based databases. Like that's probably accurate, but not that they really consulted it, but they would have been enlisting them. And even this, again, I pointed this out earlier, but this is not accurate. The FBI does not send out the tip. The genetic genealogist sends out the tip to the law enforcement. This is backwards. And this just jumps around in time a whole bunch. It's just really stupid. Okay, let me see what you guys are saying. Yeah, it's done by outside labs, And I pulled earlier, guys, I pulled up, I mean, you guys weren't here yet, I guess. I pulled up the Othram invoice, and I also pulled up the Othram pricing guide as well. Yeah, no one's attacking anybody. So here's the thing, right? They may not have needed anyone. Like, the thing is there wouldn't have been enough time to build a family tree. Like, there's that, okay? But this is what came up in one of the other live streams recently where, and this is what we're going to go to next. This is what we're going to go to next, okay? Okay, we're going to go to I've got these articles. We're going to go to these, okay? All right, so first of all, first article. This is going to explain this to you guys, okay? All right. And this one, they actually talked to Cece Moore, okay? Who's like the goddess of IGG. Police are getting DNA data from people who think they opted out. Forensic genetic genealogists skirted GEDmatch privacy rules by searching users who explicitly opted out of sharing DNA with law enforcement. Now, what's funny is this actually came out the same day that the hearing did, but this came out before the hearing did. Cece Moore, an actress and director turned genetic genealogist, stood behind a lectern and blah, blah, blah. She was a keynote speaker. This is just some background here. They look for people. Golden State Killer. The practice is not without controversy. It involves combing through the genetic information of hundreds of thousands of innocent people in search of a perpetrator. And then right here, operate without meaningful guardrails, save for the interim guidance published by the DOJ. And that's what we just read earlier in 2019. The last 5 years have been like the Wild West, Moore acknowledged. The practice relies on public trust to convince people not only to upload their private genetic information to commercial databases, but also to allow police to rifle through that information. If you're doing something you wouldn't want blasted on the front page of the New York Times, Moore said, you should probably rethink what we're doing. If we lose public trust, we will lose this tool. Despite those words of caution, Moore is one of several high-profile genetic genealogists who exploited a loophole. So this is the loophole we heard about from Gabriel Vargas. So we're hearing about it here as well from Cece Moore. Exploited a loophole in a commercial database called GEDmatch, allowing them to search the DNA of individuals who explicitly opted out of sharing their genetic information with police. The loophole, which a source demonstrated for the Intercept, allows genealogists working with police to manipulate search fields within a DNA comparison tool to trick the system into showing opted-out profiles. In records of communications reviewed by the Intercept, Moore and two other forensic genetic genealogists discussed the loophole and how to trigger it. In a separate communication, one of the genealogists described hiding the fact that her organization had made an identification using an opted-out. And I wonder who this is. Could be Miss Vargas, maybe. The communications are a disturbing example of how genetic genealogists and their law enforcement partners, in their zeal to close criminal cases, skirt privacy rules put in place by DNA database companies to protect their customers. Moore did not respond to their request for a comment. To Tiffany Roy, they should have a warrant, is saying here. There's Cece Moore. Forensic genealogy evolved from the direct-to-consumer DNA testing craze that took hold roughly a decade ago. Companies like 23andMe and Ancestry offer DNA analysis in a database where results could be uploaded and searched against millions of other profiles, offering consumers a powerful new tool to dig into their heritage through genetics. It wasn't long before entrepreneurial genealogists realized this information could also be used to solve criminal cases. In contrast, the DNA testing offered by direct-to-consumer companies is as sensitive as it gets. It tells you about your origins. It tells you about your relatives. Individuals can upload their results. Both Ancestry and 23andMe forbid police and the genetic genealogists who work with them from accessing their data for crime fighting purposes. We do not allow law enforcement to use ancestry service to investigate crimes or identify human remains, absent a valid court order. MyHeritage, home to some million DNA profiles, similarly bars law enforcement searches, but does allow individuals to upload DNA results obtained from other sources. And then there's Family Tree DNA and GEDmatch, which grant police access but give users the choice of opting in or out. Both allow anyone to upload their DNA results, but neither company routinely publicizes the number of customers who have opted in, said Leah Larkin. Isn't that wild, guys? One of the people at the hearing, right? Leah Larkin, a veteran genetic genealogist and privacy advocate from California. Larkin writes about issues in the field, including forensic genetic genealogy, which she does not practice, on her website, The DNA Geek. But even opting out of law enforcement searches doesn't guarantee that a profile won't be accessed. A loophole in GEDmatch offers users working with law enforcement agencies a backdoor to accessing protected profiles. A source showed The Intercept how to exploit the loophole. It was not an obvious weakness or one that could be triggered mistakenly. Rather, it was a backdoor that required experience with the platform's various tools to open. GEDmatch's parent company did not respond to a request for comment. In forensic genealogy circles, the GEDmatch loophole had long been an open secret, sources told The Intercept, one that finally surfaced publicly during some conference in late July. And this is exactly what we heard in the hearing, right? Did she have access to DNA evidence or genetic code during her investigations? No. Could she see everyone who'd uploaded? No, she could only see those who'd opted in. Roy, playing the part of opposing counsel, was pointed in her cross-examination. Was Binder aware of the GEDmatch loophole? And yes, and how many times had she used it? A handful, maybe up to a dozen. And this is crazy. In July 2020, GEDmatch was hacked, which resulted in 1.45 million profiles then contained in the database to be briefly opted into law enforcement matching. It's wild. It's unclear if anyone told Verrigan as of this month. So the backdoor was still open as of the month that this was written, which was August of 2023. Then they changed their terms of service. Undisclosed methods. Exploitation of the GEDmatch loophole isn't the only example of genetic genealogists and their law enforcement partners playing fast and loose with the rules. Law enforcement officers have used genetic genealogy to solve crimes that aren't eligible for genetic investigation per company terms of service and Justice Department guidelines. That's the DOJ thing we just read, which say the practice should be reserved for violent crimes, right? Again, they solved or whatever, identified the victim of homicide, but they with an explicit violation of the company's terms of service. This case presents an example of noble cause bias, said Larkin. Again, that's Leah Larkin, in which the investigators seem to feel that their objective is so worthy that they can break the rules in place to protect others. That's powerful right there. Yeah, as far as so there is, I don't know if you've seen this, Needs and Z's. I showed this earlier. There is the Othram invoice, which is interesting. Maybe I'll show that again. Let's see here. Where is that? Let me show you guys this Othram invoice because this is interesting. Let me just show you guys this. So the Othram invoice is here. So, okay. And again, in the motion for protective order, they say private lab. That's referenced several times. Private lab is referenced several times. And this is the part that I find most interesting, is this part, the Idaho State Police contract, because it doesn't say what the contract is for. I mean, the thing is this, right? if any law enforcement agency, let's put this hypothetically, if any law enforcement agency has the S&P panel, right? If they have the S&P panel, so the DNA has been extracted, it's been sequenced, they have an S&P panel. Okay. If they just say, let's just see what we get, or if they just pop it on, if they just upload it to one of these direct-to-consumer databases, right? And they by chance get a match from somebody who was a suspect, right? That had actually given their DNA as a sample, right? Then there would be no need to go any further, right? With having somebody build out a family tree and stuff. Like if you're like, let's just see what happens, right? And you get like, and you happen to get, because the thing about this, like I've said before, is like with the IGG, the plan is that you're going to get a distant relative or whatever. But the thing that is that it's only a matter of time before the suspect themselves has uploaded, right? And it will match to them. Like the thing is that it's not like it's going to exclude that and only show you distant relatives, right? It's going to show you the closest match. And if it happens to be the same person, then that's it, right? Like I even looked this up again this morning and it was like, there's nothing to stop that from happening, which makes only logical sense, right? I guess people are just still operating under this assumption that it's only going to be some long distant relative, but there's no reason for that because tons of people use these things. So if you were maybe going to enlist more help and going to build out a family tree, but then you're like, let's just see, right? Because we don't know how to, like, I'm saying we as a state law enforcement agency, for example, it's like, we don't know how to build out a family tree, but before we do all that, let's just see what happens if we just chuck it on in. Do we get a match? What does it look like? And like, you get lucky and it's like, oh, those numbers look pretty good. I don't know. I'm just saying hypothetically, right? And then there would be maybe potentially a need to still make it look like you were using IGG. Why? Because if you backdoored it, right, and you went around and you did this against the terms of service and you got somebody who'd opted out, right, you would need a way potentially to make it look like this didn't happen and you found this through IGG, right? Like the initial plan was. So now we have to make it look like it took more time. I'm just saying all this is a hypothetical, right? Now, and what would you do? You would say, well, if you get the FBI involved, now you've got this whole thing of like, well, it's not our rules, it's the FBI's rules. And, they're hard to get stuff to turn over. And I mean, we know, even when there's nothing shady going on, we know that, right? It's a lot harder to get discovery. There's all these other issues and it buys you time at the very least, right? And that's what we saw. We saw months go by, as I pointed out earlier, before finally there was any mention of the FBI and them being involved. And then it was like, oh, well, they deleted all their stuff. But even the way that it's described doesn't fit with what happens. It's not accurate. It's like, so I mean, and even this right here, Idaho State Police contract, this right here kind of looks to me like they thought they were going to need Othram to perform more services. Okay. Like, for example, building out a family tree. They paid for this contract, right? Because they thought they were going to need their assistance. Now, why would they maybe decide they don't need their assistance? If they just get lucky and they're like, let's just see, right? I don't know. These are just some thoughts. This is like, because we know that the FBI doesn't do the entire DOJ document. They outsource it, right? And we even heard that from the witnesses. We reviewed it yesterday with the testimony. Like they even said, like when they hire us, it is our case until we turn over the lead. And even, again, like I pointed out, even just recently in the motion for a protective order, Bill Thompson is completely incorrect when he says the FBI got a lead and provided us the lead. It's just not how it works. And we're going to get more into the whole thing about Othram here too. Let me go back to this because I've got more. Don't worry. This is not all. So, Where is it? Okay. Yeah, I mean, Stevie, I would agree with you, right? It should be, but it's totally not. It's absolutely not. It's totally not, right? It's absolutely not mandatory. It's just right. They have. That is accurate. Right. Trying to be exactly. That's what I'm saying. So that's the thing, right? Is so if you're that's we heard that in the hearing yesterday. So that's what you can do, right? If you're like, let's just see before we take the time, you get this contract in place. It's like before we take the time, we can maybe, like I just read, right? The part about where it's like they feel like a noble thing to try to get something solved quickly, right? They'll cut corners because they feel justified. And that's when you have people use, and they even said that at the hearing. Involved in the trials. Right. So they don't use the word Othram, but again, I did a lot of research on this because, like, well, I guess what happened was Kevin Fixler from the Idaho Statesman dug up that receipt or invoice or whatever, right? And that's how people learned that Othram was potentially involved. Now, there's also a closed hearing, I guess, where a source was there. So it's not, we couldn't watch it, but like apparently in this hearing, Ann Taylor referenced Othram many times, and the state tried to deny it. And she, they were fighting over that, but she was like, yeah, Othram was involved. You know what, though? That could be right, but I'm wondering if it was maybe potentially the suspect himself. What Stevie B is saying here. Apparently, the Kohberger family's outraged because of the possibility IGG mattress family member who opted out. Okay, so we're going to get to this because, guys, gets crazy. Flash fan, you don't need to apologize, and I appreciate you always trying to keep things in check. And I know you're a mod, so you're used to that. I appreciate it. But you can, you're here to have fun and not, be on clock, as they say. Yeah. So yeah, I mean, I'm also not about fantastical conspiracies. You guys hopefully know that by now. That's right. If it would explain why it came back, so that's right. Yes. Exactly. Because the timeline doesn't make sense. Yep. Exactly. And we're going to get to where I'm getting goosebumps already. Wait till you guys see. I've got more. Okay. So, all right. Yes. It's okay. It'll make sense, hopefully, I think. So, appears that violations have also spread to ancestry. Target testing. None of the people wanted to respond to the question, which is fine. As it turns out, the genetic genealogy work in the Golden State Killer case was also questionable because the breakthrough, Barbara Ray Venter uploaded DNA from the double murder to MyHeritage. Wow. In his opinion, law enforcement is entitled to go where the public goes, Ray Venter told the paper. Just how prevalent these practices are may never be fully known, in part because police and prosecutors regularly seek to shield genetic investigations from being vetted in court. Oh my God. They argue that what they obtain from forensic genealogy is merely a tip. Wow. And here we go, guys. That's exactly what's happening in Idaho, where Bryan Kohberger is awaiting trial. For months, the state failed to disclose, that had used forensic genetic genealogy to identify him as a suspect. A probable cause statement methodically laying out the evidence that led cops to his door conspicuously omitted any mention of genetic genealogy. And as I've said before, they leave out the letters IGG, but they hint at it. It's just plausible deniability, in my opinion. Kohberger's defense team is asked to see documents related to the genealogy work as it prepares for an October trial, but the state has refused. saying the defense has no right to any information about the genetic genealogy it used to crack the case. Prosecutors, look guys, look, here it is. Remember I said, don't worry. Prosecutors said it was the FBI that did the genetic genealogy work, and few records were created in the process, leaving little to turn over. But the state also argued that it couldn't turn over information because the family tree the FBI created was extensive, including the names and personal information of hundreds of innocent relatives. That's literally what it said in the document. And the privacy of those individuals need to be maintained. According to the state, it shouldn't even have to say which genetic database or databases it used. Kohberger's attorneys argue the state's position is preposterous and keeps them from ensuring that the work undertaken to find Kohberger was above board. Quote, it would appear that the state is acknowledging that the companies are providing personal information to the state and that those companies and the government would suffer if the public were to realize it, one of Kohberger's attorneys wrote. The statement by the government implies that the databases search may be the ones that law enforcement is specifically barred from, which explains why they do not want to disclose their methods. A hearing on the issue is scheduled for August 18th. That's the hearing we watched yesterday. A search of all of us. Okay, while proponents of forensic genetic genealogy say the individuals they're searching have willingly uploaded their genetic information and opted in to law enforcement access, RAM and others aren't so sure that's the case, even when practitioners adhere to the terms of service. If the consent is truly informed and voluntary, quote, then I think it would be ethical, lawful, permissible for law enforcement to use that DNA to identify those individuals who did the volunteering, oops, end quote, RAM said. But that's not who's being identified in these cases. Instead, it's relatives and sometimes very distant relatives. Our genetic associations are involuntary. They're profoundly involuntary. They're involuntary in a way that almost nothing else is, and they're also immutable. I can estrange myself from my family and siblings and deprive them of information about what I'm doing in my life, and yet their DNA is informative on me. You can't consent for another person. To date, efforts to rein in the practices of violation. Okay, here we go. To date, efforts to rein in the practices of violation of the Fourth Amendment have presented some problems. A person whose arrest was built on a foundation of genetic genealogy, for example, might have been harmed by the genealogical fishing expedition, but lack standing to bring a case. In the strictest sense, it wasn't their DNA that was searched. In contrast, a third cousin whose DNA was used to identify a suspect could have standing to bring a suit, but they may be hard-pressed to prove they were harmed by the search, right? That's exactly what the issue is. This is kind of exactly what I've articulated before, right? If police are getting hits to suspects by violating companies' terms of service, using databases that bar police searching, that raises some serious Fourth Amendment questions. And again, like I've said, but for who? Now, the thing that's different is that the for who disappears, I believe, if the for who is the suspect themselves because they have uploaded their DNA. Now you're in a world of what the fuck are we going to do now? Because no expectation of privacy has been waived, Ram said. Of course, ferreting out such violations would require that information be disclosed in court, which isn't happening. Ugh. At present, the only real regulators of the practice are the database owners, private companies that can change hands or terms of service with little notice. GEDmatch, which has at least once spent its terms to accommodate police, was started by two genealogy hobbyists and then sold to the biotech company Verogen, which in turn was acquired last winter by another biotech company, Petagen. Jesus Christ. Wow. For now, the best way to regulate forensic genetic genealogy is by statute. Now, this is where we get to, we've talked a little bit about this, right? Because this hasn't happened yet. Maryland is unique. Maryland lawmakers passed laws to restrain the practice. It requires police to obtain a warrant. But the thing is this, they're the only ones who've done it. Currently, police use surreptitious methods to collect DNA without judicial oversight, mining a person's garbage, for example, like for items expected to contain biological evidence. And again here, in the Kohberger, so right, the Maryland law also requires police to obtain consent from any third party. So dad would be an example, right? In the Kohberger case, police searched his parents' garbage, collecting trash with DNA on it that the lab believed belonged to his Kohberger's father. So that's a third party. Montana and Utah have also passed some laws, but it's not as strict as Maryland's. Yeah. By the time people started worrying about this as a policy issue, it was too late. And that's coming from Cece Moore. By the time the vast majority of the public learned about genetic genealogy, we'd been quietly building this incredible tool for human identification behind the scenes. People sort of laughed like, oh, hobbyists, you do your genealogy, you do your adoption, and we were allowed to build this tool without interference. Fuck. Moore advocated for involving forensic genetic genealogy earlier in the investigative process. Doing so, she argued, could focus police on guilty parties more quickly and save innocent people from needless law enforcement scrutiny. We can stop criminals in their tracks, she said. I really believe we can stop serial killers from existing. We are an army. We can do this. So then after this was published, the founder of the DNA Doe Project, which actually Vargas worked for that for a bit. Gabriela Vargas, she worked for that for a bit. Wow. So this is what she said. We have always been committed to abide by the terms of service for the databases we used and take our responsibility to our law enforcement, medical examiner partner agencies. In hindsight, it's clear we failed to consider the critically important need for the public to be able to trust that their DNA data will only be shared and used with their permission and under the restrictions they choose. We should have reported these bugs to GEDmatch and stopped using the affected reports until the bugs were fixed. Instead, on that first day when we found that all the profiles were set to opt out, I discouraged our team from reporting them at all. Mother of God, I now know I was wrong and I regret my words and actions. Oh my God, oh my God, oh my God, oh my God, oh my God. Oh, y'all. Right. Again, the FBI doesn't do family tree building. That's the only thing. I don't know a Macintosh Whitaker. That's funny. So it seems that law enforcement is saying that the company terms of service have no legal standing to enforce the policy on the government. I mean, even that would be better than what we have. I mean, yes. The thing is like they're supposed to follow it, but like there's not laws in place, right? That's really the problem here, because until there's laws, which comes from the legislature, right? Until there's laws in place, it's really more like doing the right thing or abiding by guidelines, in which case you might be risking like civil action. And, you know, again, like we read about earlier, the noble cause and whatnot, right? Where it's like, you know, yeah, we're okay violating the terms of service if like it's going to solve a case quicker. If there were laws in place, then what they would, and that's part of the problem, right? Because I know that there's been talk about that using these backdoor procedures is illegal. That's what actually got me looking into this, because I'm like thinking to myself, I know there's not really laws in place, you know? And so therefore, is it illegal? It's not illegal. It should be illegal, but there's not laws in place to make it illegal, right? In Maryland, it would be. Maryland is the exception. In Maryland, it would be illegal to use these backdoor procedures. I mean, in fact, like we just read, you have to have a search warrant. Like in Maryland, they have laws in place. But that's about it. That's about it. So the issue you'd be facing is violating terms of service, right? But not illegal. Does that make sense, guys? Yeah, I know, right? And shout out to American Princess. Shout out to everybody that's here. Glad you guys are here. You know, I've been working my way through this like logically since the beginning of this live stream, like step by step, you know. And so, okay, let me pull up the next thing. Hey guys, guess what? It gets worse for anyone who hasn't seen this already or heard of this. So here's the thing. Kevin Fixler, the Idaho statesman, has, again, he's like one of the key people for journalists, right? And I think I already read something else by him earlier, but yeah. So, oh right, I was referencing that he's the one that found that Othram invoice. So, so this luckily was shared with another agency because the Idaho Statesman has a paywall. So, but this is the same article. All right, ready? Brace yourselves. What if Bryan Kohberger, the man charged with the University of Idaho student stabbings, helped lead police right to him? His own attorneys may raise the question, including at trial. So this is from, by the way, from February 25th, 2024. Kohberger is accused. We already know what he's accused of. She still wants to know what led police to her client as a suspect. All right. The clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. And we've heard her say this over and over again at the hearings. Taylor told the court at a hearing last month, over a year into this case, and we're not sure. I know different pieces, but I don't know where they fit together. And see, I remember I used to hear this and think, oh, the car. Well, no. Because again, we heard that come out in that hearing that the car wasn't until really, it was December 20th, but in the affidavit, they put November 29th. That right there, again, incorrect information in the affidavit. There goes that's your motions to suppress right there, right? Okay. Depending on the circumstances that come to light, could be grounds for a constitutional rights challenge over the methods police used to find and charge Kohberger's defense. So again, remember, like I said, it's not yet illegal because there's not laws in place. And that's why we keep hearing them reference constitutional rights challenge, because that's how they would have to deal with this, sadly. In a probable cause affidavit, police describe using traditional investigative techniques to arrive at Kohberger as a suspected killer and close an almost 7-week manhunt that confoundedly ended on the other side of the country in eastern Pennsylvania. DNA evidence also factored for police to allege they had their suspect, but only after the other elements established through surveillance footage. This could have been put in scare quotes, I would say. When you look at the timeline, it doesn't make sense. Of the suspect's car and Kohberger's cell phone location data, according to the affidavit, right? But 6 months after his arrest, state prosecutors acknowledged for the first time in the motion for protective order that an advanced DNA technique known as IGG initially led investigators to Kohberger. Police made no mention of the FBI's use of IGG in the affidavit. A single source of male DNA was pulled and processed from a leather sheath, blah, 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 blah. We know all this. In the court filing that revealed the FBI's use of IGG, this could have been in scare quotes also, I think, Latah County Prosecutor Bill Thompson argued that the state was not required to disclose the DNA technique. Prosecutors did not intend to introduce it at trial. He said it was irrelevant to the defense. Instead, they planned to present a comparison of DNA evidence police obtained from the buccal swab, right, with the knife sheath. The IGG process pointed law enforcement towards Kohberger, but did not provide them with a substantive evidence of guilt. He said in the court filing, the IGG information is not material to the preparation of the defense. For 8 months, the two sides fought over the release of the IGG records to the defense through the legal process known as discovery. Judge John Judge granted the defense at least some of the FBI's. Now, this is where I get confused because I read this earlier tonight, right? Some of the FBI's records from the IGG process. So that leads me to believe that there's some records there. Now, remember, anything that would actually show that they, okay, let me back up. We know that they don't do the family tree, but anything that could show that if in another galaxy, in another world, another dimension, they did that, remember, it was poof, goodbye, disappeared, right? I mean, literally, I was going to ask myself, so what did they turn over? And then I keep reading, Chelsea, what was turned over? Because that's my question is like, what did they turn over, right? And what may have been withheld is unclear to the public because the documents were sealed. Yeah, it's a really important question. And there's Tiffany Roy. She was referenced in the last article you read. A longtime forensic DNA expert said Kohberger's defense team is perhaps working towards leveraging its recent access to the FBI records to make a constitutional rights claim against illegal searches and seizures under the Fourth Amendment. Prosecutors' attempts to conceal information about use of IGG to identify a suspect alone should give the public pause. I don't understand the government's argument here, Roy said. You have an obligation to expose every part of your investigation, and then we decide what is important. If the FBI were doing the right thing, they wouldn't have to make those arguments. Put it all out on the table. All right, next step. Prosecutors won't say which websites FBI used for IGG. Already, the Kohberger case has broken new ground. Never before in a case has the defense team received access to this level of IGG records, which is crazy because we know it's like not nearly enough, right? The next battle between the attorneys on each side of the Kohberger case could be over whether the defense will be allowed to present IGG evidence to the jury at trial. IGG records have been introduced at trial a couple times before, but only when prosecutors chose to do so because they felt it was beneficial for them. Wow. It's potentially novel in that way. I would try to get all this information in front of the jury. I would try to just muddy the waters. For instance, the prosecutors have not publicly disclosed which genealogy websites police used to land on Kohberger, only that the FBI submitted the crime scene DNA to one or more of the publicly available services. And again, if they did, like maybe that was their involvement, right? Like I said, getting them involved so that then you've got this third party where it's like, and then you can be like, we don't know what happened, right? So maybe that's what they did. Maybe what they did was they did the thing where they like, you know, I'm a consumer and they just pop, you know, or they do whatever, right? I'm just saying they, like, in other words, they can submit it, right? Just here's the sample, boop, right? And then wash their hands of it because then the rest of it's taken over from, you know, a third party. And then, you know, and then you get, and then you hire a third party, a public or a private vendor, as it said in the DOJ thing, and they do the work, right? You know what I mean? And then they pop back with the lead. And then you can, and then all you've done is you've just done exactly what it says here, potentially. Oh, we just submitted it to a database. You know, I don't know. You guys see what I mean, though? It's like, you can kind of like, when you think about like at a factory, right? Where it's like, I know there's a word for it, like a separation of each step, right? One person does one little thing and then they pass it along. The next person does, so that in other words, like if so there's a problem, right? Somewhere along the way, it's almost impossible to identify, but also everyone else can say, well, it wasn't my fault. It was the person behind me or a person in front of me. Does that make sense? Law enforcement primarily works with two lesser known websites, but at least in some past instances found ways to access DNA profiles on a more widely used platform with more users. So if they didn't get what they wanted from those databases and need to fish around in other databases, I would be really uncomfortable with that. The reason they would have done it if they did is it gives you access to a much larger number of people, a much larger number of matches, and in theory, that would make your job easier. If the IGG records now in the defense's possession divulge that FBI investigators conducted themselves in an improper way or violated expectations of privacy to get to Kohberger, it may help create legal openings for creating doubt about the evidence. It's a good tool, but the question is, does it violate civil rights? Some say it's just another technique, but this technique involves something much more intimate than a body cavity search. It's an every single cell in your body search. Oh, Joshua Ritter. I know him. I mean, I don't know him personally, but you know, from you guys know who he is probably. Faced with the task of defending Kohberger, Ritter said he would pursue the same approach and try to create questions. Yeah, there it says. Yeah, the True Crime Daily, the Sidebar podcast. Okay, the probable cause affidavit was well done and showed high-level police work. But the remaining evidence becomes very tenuous and circumstantial if the DNA is removed from the equation. That the defendant lived in the area, had suspicious driving habits, and possibly turned off his cell phone makes it for a much harder case for prosecutors to prove beyond a reasonable doubt. Okay, now here's the dad trash. Police also said they linked the crime scene DNA to other DNA acquired from the trash they took from Kohberger's family home in Pennsylvania. The comparison showed that the DNA from the trash was the male suspect's biological father. Which again, how did they know that before they had his book? Hold on, have we not asked that question before? Back up. Okay, they collected the trash on the 27th, and apparently they had the DNA profile on the 28th. That already baffles me because I think it takes more than one day, but whatever, even if you give them that, okay? Collected the trash on the 27th, had the results on the 28th, and that would be timely, wouldn't it? Because they made the arrest on the 29th. So they would need it back in a day. But here's the thing. I mean, has nobody asked the question, though? Oh, I guess they're saying male suspect's biological father. Okay, no, that's fine. It still doesn't make any sense how they had that back in a day. Fuck. Yeah. Now it's getting to the part. It's going to be getting to the part. Don't worry. Thompson, however, tried to get ahead of a possible Fourth Amendment claim in the Kohberger case in his arguments against Judge, giving the defense the IGG records used to find him. The defense would have to first establish that the defendant had a reasonable expectation of privacy. All right, I remember this part. In addition, local law enforcement did not use FBI's IGG results in support of Kohberger's arrest. These are all the arguments that have been made. We've all heard this. This is all from the trials. This is all taken from the documents, right? There's the fruit of the poisonous tree. Oh, Duke University. That's in North Carolina. If a person using a genealogy website didn't agree to allow police to include their DNA for profile IGG searches, it amounts to a possible violation of the terms of service by law enforcement. Again, terms of service, right? We're looking at probably a civil suit, right? But not illegal because there's not laws. But I'm not sure if it raises constitutional questions. He said it raises a larger question of, is there a constitutional right to genetic privacy? And we don't have clear answers. We don't know what the courts will do with it, even if it is super interesting and an important problem. At the August hearing, judge prodded the defense on the relevance of the IGG records, including a hypothetical situation where the FBI was found to have skirted the rules to arrive at Kohberger. Ooh, he questioned whose constitutional rights would have been violated in this circumstance. Wow. I don't want to get into the Fourth Amendment issue here. I think that's a gray area for sure. What it suggests is that folks should probably be cautious about sending their spit to some corporation, but I don't know how much that's going to bear on what ultimately happens given the sequence of what happened with Mr. Kohberger, he added. After police found the knife sheath, the Idaho State Police Crime Lab, we covered this earlier, right? No matches were found in CODIS. This is, again, we covered this earlier tonight. This is taken straight from the motion for a protective order. DNA was sent to an unidentified private lab to begin the IG process. I mean, again, I appreciate Kevin Fixler here. This is all based on the court documents and the hearings, right? That lab is believed to be Texas-based Othram, right? And the reason it's believed to be is because of that invoice. We already looked at that, which Idaho State Police has, right? We looked at this, said has maintained a contract, right? And I was like, that's weird, right? The contract. The defense, I said this earlier too. The defense has twice said the private lab was Othram, though prosecutors have never confirmed the name of the lab, and Othram has not responded to statesman's request for comment. Now remember, Othram does everything with DNA all the way from extraction to then sequencing, all the way through the SNP and all the way through the family tree and all that. Othram can do it all from start to finish. So for anyone who involves Othram, they could turn over a sample that needs to be extracted. They could turn over a sample that's already extracted but needs to be sequenced and on and on and on, right? Law enforcement working the cut. And again, this is exactly what we just read from the motion for protective order. This is what the state says, right? The FBI would take over and investigators began building family trees. The FBI sent a tip. They don't do that to investigate, but produce limited records. Again, all of this is what we already read. Nonetheless, judge at least partially awarded the IGG records. Now, brace yourselves for this, guys. Kohberger submitted for DNA testing, the neighbor says. Now, this is where it gets insane. Still another scenario could exist. The FBI may have used the crime scene DNA to conduct an IGG search and instead landed directly on Kohberger's own DNA profile. This is like this hypothetical I referenced earlier. Ostensibly, this would give them a direct hit. Because like I keep saying, in my mind, I'm like, see, I have done this. I submitted my DNA to MyHeritage, right? And so it's like, this whole time, I kept thinking to myself, well, obviously, if somebody submits their DNA, it would match directly to them. But like, no one's been talking about it, right? And it's like, whenever it's discussed, it's just the possibility of a family tree and distant relative and whatnot. And it's like, in my mind, I'm like, well, you know, I did that. I did my hair. So like, you know, I don't know. Again, I mentioned it earlier. It's just my brain. Yeah. To me, it seemed like too obvious and too, also like, how to say it, horrific, if that's what happened, I guess. Like, how could that be? And how could this even be going on? Like, but yeah, I know it could be going on because, you know, it's bound to happen one of these days, right? Enough people submit their DNA and then, you know, I'm sorry I haven't been reading the chat, but like I'm looking at I've got an external, you know, separate monitor over here. And I've got this all pulled up and I'm like, I'm super focused in on this. Yeah, but I'll look at the chat here in just a second. So, because this is important, right? Kohberger, more than a year before the U of I student homicides, told a fellow WSU graduate student that he had submitted his DNA for testing to learn about his ancestry. The neighbor told the Statesman last year. The neighbor spoke on condition of anonymity over privacy concerns. Ironic there, right? Don't submit your DNA, neighbor. He talked about his ancestors, the neighbor said in an interview from the entry of his apartment. He had some sort of DNA test. I don't know how he got to that point. It was just interesting to him. Now, here's the thing. We don't know who this neighbor is, right? The neighbor, who knows? The thing for me, though, is that whether the neighbor says that or not, again, like I said, to me, this was already what I was coming around to logically as I've been working through this live stream by live stream, document by document, hearing by hearing. My brain was working towards this as maybe the only possibility because nothing else makes any sense. And like I said before, the way that I work on this stuff right in my brain, when it comes to like not trying to speculate or just like make stuff up, like obviously, right? It's like you've got all these puzzle pieces, so to speak, right? Especially when you've got so much stuff under seal. And it's a process of elimination. And that's how I've been working through it, of like, you look at the timeline, right? You look at what the DOJ says. You read the documents over and over and over and over and over again, right? You will see what's missing and what's contradicted. And then you keep scrolling at it, as I say, right? You keep scrolling at it, and eventually it's like, it can't be this, it can't be this, it can't be this, it can't be this. But the funny thing is, like, my gut from day one, every time you hear about IGG, because again, I've done this, I've submitted it myself, right? As someone who's done that, this isn't just like some like hypothetical or like abstract thing, right? Like, this is the thing of like, yeah, like, it only makes sense that if you have submitted your DNA, it would match to you. The distant relative thing only works if that's the closest thing, right? It's going to find the closest match that exists. If that matches you, it finds that match, finds you. You know what I mean? And like, but like, I set that aside. I will set the gut aside, right? Because that doesn't matter, right? And I work through it step by step. And then it's like, anyway, am I making any sense? I need to see what you guys are saying in the chat. But this is, I've been working really hard on this. Hopefully I'm making some type of sense. I know, right? Judge, for sure. Hello, welcome. If you're new, welcome everybody. If you're new, the Stevie B says the Othram contract was already in place. I mean, well, if it was, the one that I pulled up on the invoice was dated for November 29th of 2022. So maybe unless it was renewed. Right. And that's what you're saying here, Rolo, but I know I'm behind. I'm just catching up. That's exactly what I was thinking. And I don't know if you were here earlier, but when I pulled up the invoice, that was exactly what I thought, because it had the fee for the S&P, right? And then it just had that vague contract that it didn't specify. And that was exactly, literally what I thought was that they sent it off, they sequenced it, they did the snip thing, right? As we saw, the $5,000 charge. And then potentially somebody was like, let's just see if we can get lucky. Let's just pop it on in and just see what happens, right? On one of these consumer databases, right? And then found they didn't need to do the rest, but then had to try to, they couldn't say that that's what happened. If that's what happened, they couldn't say that's what happened. So now it's like, we need to make it look like it's taking longer. And then we're going to have to try to explain this and then blah, 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 right? And then fill in the blanks with things that don't make any sense, probably. Are you going to bed, Flash fan? Well, thank you for being here as always. And I hope you have a good sleep. Happy holidays as well. Yeah, I agree with this. This is where I'm at with this, because here's why. Because everything that references the FBI in the motion for protective order is completely incorrect. It's like not even trying to make it seem like they were legitimately involved. The only thing, again, I pointed this out earlier, the only thing that makes me have a little bit of pause on that is that we saw it. Let me pull it up. Hold on. Is this one? No, wait, that's not the right thing. Hold on. Coeur d'Alene. This one. The only thing is this. The only thing is this. This is the order. Okay. So the state submitted to the court in camera all the IGG information pertaining from both the FBI and a private laboratory. This is the only thing that is like, and again, that was referenced in one of the articles I read tonight. That's the only thing I'm like, okay. But then again, I asked the questions like, so then what was turned over? And that was exactly the next question that was said in the articles. Like, so what was turned over? Because remember, they poofed goodbye, everything was gone. They didn't have anything, right? So like, for example, like if what they had to turn over, we don't know because it's under seal, but it could just be something like, we're the FBI and like, I don't know, right? Because it's like, it can't be anything substantive, right? It can't be anything about like, it's almost so convenient, right? It can't be anything about any work that they did, which is nonsense to begin with because they don't do the work. They bring in a private vendor, as I already covered. So they don't do the work anyway. So the whole thing is like so circular and nonsensical. It's like circular, nonsensical, non-reasoning, if that makes sense. Like that's what this is like. It's like trying to send like a goose on a wild goose chase to chase another goose who's chasing a goose who's chasing a goose. That's what this is like. And thinking about it that way, boy, oh boy, if nothing else, isn't that going to make it hard to get discovery, right? And hard to know which channel to go through. I mean, and even like we heard in the hearing, right, with Brett Payne, it's like, well, I don't have it. They have it. And then it's like, well, I asked them and they said, you have it. And it's just like this whole thing. So again, anything turned over from the FBI, right, is like, well, what could the thing that could be turned over is simply something saying we have to delete stuff or whatever, right? And then that, because it's under seal, we just don't know. And like that's supposed to you know, like obviously you don't have to believe that proves they did anything, right? It's just I don't know. But this is the only thing, because coming from the judge, right? This is coming from judge. This is the only thing that indicates that there was anything to show from the FBI. But just again to qualify that, it doesn't mean they did anything with IGG. In fact, I would say it's impossible because they don't do it. So, oh, you're saying that they all did it. Okay, interesting. Flash fan, thank you so much for being here. We love you. You're the best. I mean, make sure you get enough sleep though. Well, it's a good thought. And the thing is that it could get tricky, right? Because, you know, getting it from the neighbor's trash can. Well, it just depends on which neighbor, right? Because some of the neighbors have private roads and some of them don't. Which reminds me, we need to circle back on all that stuff with the trash. But oh, that's interesting. Huh. Where did you find that, Stevie? Some random lady edited what now? Oh. We covered that. Let me pull that up. We've covered that. I don't remember reading this, but you know, I've read a fuck ton of documents. So let me find that motion. Luckily, I have this pretty much memorized as to when all this shit came out. Let's see here. Righto. This is in the declaration. Okay, let's just. This is when you've spent a lot of time looking at the docket. Can find things quickly. Oh my God, why is it? We don't need it that zoomed in. Okay. Right. Well, unless it's a private road. You can share the doc in the Discord. By the way, I'll put that link in for anyone who wants to join. In the Discord, you guys can send links. You can send videos. We can do all the things in the Discord. You can also use all the commands, Nightbot commands. So, oh, Flash already said that. Thank you, Flash. That's so funny. Jinx. So, okay. I'm looking for the thing. So, here it is. Found it. I've reviewed a copy of an Idaho State Police announcement dated July 28th, 2021, that the Idaho State Police Forensics Laboratory Security Grant Fund. Interesting. Oh. But here's the best part. Right. They contracted with Othram. Okay. So in other words, let's just be clear. This doesn't mean that the Idaho State Police Forensics Labs is doing IGG themselves, first of all, right? It's a grant to them. So in other words, because it's public, it's government money, right? To them. Essentially, let me just explain this. The grant means it's public money, taxpayer dollars to them, to the Idaho State Police. So then they can take that money and pay Othram and hire Othram. That's what that's for. But this is where it gets interesting though, because this, so hold on. So Othram Invoice. So I mean, maybe potentially this is like something where they're just like, they have to pay this monthly. And this was like, maybe it was just like by happenstance, it was time to renew this. Oh my God, why is it being stupid? Like time to just pay up for for the month or whatever it is, right? I don't know, because it is on the same invoice as this. And again, Ann Taylor has come out and said twice, said in that one article, that she thinks it's Othram, I guess at least partially because of the contract. And I mean that. So the only thing the only question here would be like, okay, so this is December 29th, 2022, but like they have that grant. Now, let me think. Okay, let me think. Okay, let me think. So the grant, right? Okay, the grant just means they're getting government money, right? The state police is getting government money. So the way it would work is like this Idaho State Police has this money, right? And then, this makes sense. So, okay, so just because they have the grant secured in 2021 or whatever, it doesn't mean that they would be spending that money until they need it. So here's what I mean by that, okay? If you get a grant, it's like, here's this money to be used for this thing, right? So it's not like they don't just go ahead and pay the company, right? Like the way it would work, that makes sense when you look at this, right? So the grant is like, okay, you've got this pool of money, and then when you need it, there it is, right? Because they have limited funds, so they can't just take it from another pot, if you will, right? Government money. So that would make sense, right? So like they probably, my guess is however much the grant is for, let's just say it's for, I don't know, I'll just make it up, $500,000, say, right? Maybe, right? Whatever it is. Could be more, could be less, could be anything. But my thought is like they've got that grant sitting there. The grant is money that belongs to the Idaho State Police until they choose to use it. And the grant would say they have to use it specifically for this purpose, right? And so then they have, when they need to hire Othram, they don't have to be like, oh, well, how are we going to get this money? Where do we take it from? Are we going to have to fire a bunch of people to pay? No, they go to the grant, they take the money from the grant, and then they pay Othram. That's what I think would be going on here. So in other words, both can be true. That they can have the grant established in 2021, right, where they get that pool of money, and then as needed, and who knows, maybe they haven't, I don't know if they've had to use them before, who knows, right? Like potentially, but it would be as needed, right? So then that would make sense though, as to why that says contract. Am I making sense to y'all though? Right. No, the FBI does not do the tree. They don't know how to do the tree. We've heard that from many sources, including the people that testified at the hearing. They don't do the tree. They don't do the tree. Literally the DOJ document that I covered earlier literally says their protocol. It's like, and then it's like you contact a third-party vendor. It literally says that. And it says the words third-party vendor like a bazillion times. They don't do it themselves. Right. All DNA. Well, is that in, I mean, I would imagine that's in these like, to me, all DNA could just mean all DNA that they found. It doesn't, I mean, like, I could see that as being like, they collected as much DNA as they could potentially, right? Because they didn't find anything except for on the button snap. So, like, in other words, they didn't find DNA elsewhere, but they found DNA on the button snap, and all of that was submitted. Maybe. Right. I agree, Stevie. Yeah, I think that's right. I think it's a retainer and then payment. Yeah, that makes sense, right? That makes total sense. That's pretty much what I was trying to explain with the grant. I think it's one and the same, right? Yeah. That makes sense. Whether they have a retainer and then they pay them as they need services, or, the grant is sitting there with ISP and then, yeah. But I think either way, it's pretty much the same thing. I think we're on the same page with all that. So, yeah, my scroll brain works really fast. Well, I mean, people tell me. So, I think I already found the part, though. Didn't I already find the part? Okay, let me go back. I thought I already found the part. Okay. I was really hoping that Frankie Figs could be here because she just got approved to do FGGS. Okay. So oh, well, yeah. So this is the thing we read. Yeah, the interim policy. You know what's so interesting is this part, right? Like, take a look at this, guys. Here's the thing. Here is the thing. Means the donor of the forensic, oh my God, it always does that. A forensic or reference sample. Look at this. This is highlighted. Isn't this so crazy? Like, in hindsight now, may be related. It's not because she's saying they may be related. It's because she's saying that, like, because it may also not be related because it could be the person. I think that's what this is. Wow. Emphasis added. Wow. And here's the part, we've read all this. They are required to Yep, I covered that earlier tonight. Oh yeah, Riley Nolan. That's who the invoice was sent to from Othram. I bet none of these exhibits are attached. Let's see here. Oh. I'm aware of specific news reports in this case regarding Mr. Kohberger's DNA is published on the New York Times. All right. That they worked with Othram. Okay, let me see what we've got here. All right, here we go. Excelente. Whoever it was that said to keep scrolling. I think it was you, American Princess. Thank you. All right. Aha. All right, here it is. The fund, the genetic genealogy in July 2021. In addition, by ISPFS securing federal grant funding, we can offer these services to local county and state agencies, to local county and state agencies at no cost to the local law enforcement agency. Right. So that's kind of what I was saying, right? Because, like, they're not going to have the money when they need it all of a sudden. In order to facilitate this, they have formed a state genetic genealogy investigation team consisting of laboratory personnel, an Idaho State Police investigator, and a representative from Rocky Mountain Information Network to identify cases eligible for testing under this grant. So let me just be clear. This would make it sound like they've got people doing the work. No. You have to read the full sentence. They're just going to identify cases eligible for testing. So this makes sense then from what we read earlier in the motion for a protective order, where it looks like they've got state people working on it, and then all of a sudden they're like private lab. But what's weird, why the fuck don't they say Othram? Why? Because it's like obviously it's Othram though, right? Like what? I mean, what the fuck? Or I don't know, do they not mention Othram? Okay. Wow. So once the case is identified as eligible, the team is reaching out to local law for blah, blah, prosecutor. Yeah. State team is resource for the local law enforcement. Idaho now has a formal. Oh, there it is. Just kidding. There it is. There it is. So what the fuck then, Bill? What the fuck? Like the audacity to, in your motion for a protective order, keep saying private lab, when like, okay, it's not even, never mind. We don't even have to be like looking for stuff and like, you know, researching. Like it's here, right? It's right here. It's right here. It's right here. There it is. Othram. Like, what the fuck? Oh my God. ISPFS is ensuring the Othram follows accepted laboratory processes and procedures and complies with the DOJ Interim Policy. What I want to see, guys, keep an eye out, okay, as we go through this, where in this process, because now they've got a specific process laid out. This actually is really helpful because there's a specific process laid out. Now, all this does is just show just the extent to which Bill Thompson was being a sneaky weasel. Right? Like the weasel level is at a new high here. So that, like, what the fuck? But what are we going to see any step in this where it explains the involvement of the FBI, right? Because in other words, if anything, they've narrowed down their process by engaging in this grant and all this, right? They've just made their process really clear and transparent, mind you, that here's what it is. It's ISPFS and they're working with Othram and they've got money and here's how it's going on, right? And like, at what point is the FBI involved? Let's keep an eye out. My guess is it's not going to say, but we'll keep an eye out. The state team is a resource for local law enforcement. Idaho now has a formal contract with Othram, right, to conduct the genealogy testing and forensic genealogy testing. That means family trees. So again, when you look at that invoice, right, it looks to me like they didn't need their services further. The thing is this. There would not have been time. Okay, if it was a normal thing, right, where there wasn't like a direct match or whatever, right, it would have taken so much more time for them to build the freaking family tree. And that's why it's something, right? It's like somebody, it didn't come to that, I think. Unless maybe it was Othram. Maybe it was Othram who actually just, you know, they popped the DNA knife sheath sample in and said, hey, well, we got a direct match. There you go. Done. Job done, right? Job done. ISPFS is ensuring the Othram follows accepted laboratory processes and procedures and complies. Right. I think I already read this, but boy, oh boy, what a mess. We want to be very clear that the local or county law enforcement agency will retain jurisdiction and responsibility for the case. The state team is in place to identify cases, coordinate with local entities, provide investigation resources, safeguard that the blah, 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 blah. This is all just whatever. They're committed to ensuring that this lab science and genealogy work is robust, treated appropriately. Sorry, that was a weird sound. And that the contract with the private lab and federal funding are spent separately. Hang on. Oh, okay. Right. I my brain interpreted this as separately and not appropriately. Sorry. Okay, that's fine. They're just saying we're not going to waste taxpayer dollars. If more funding resources are needed to support this effort, they will obtain resources in support of all, blah, blah. They're an equal opportunity employer. Well, that's good to know. Okay, and then here's the interim policy. We've already covered this tonight even. Let's see what else we got on here. Huh. FGG is not current. Wow. Wait, what is this list? Founding member. Okay. FGG is currently not within the scope of an accredited forensic public laboratory. Forensic laboratories participating in CODIS are credited. Huh. Yeah, this is a mess, man. Meh. Oh, here we go. Right. A lot of this is kind of echoing what we saw on the other DOJ thing. Yeah, this is all pretty much what we saw there. Third-party samples, we covered that earlier. Interesting. The genetic genealogy database terms of service must be adhered to. Can I highlight, please? Adobe. Hey, Adobe. Hey, okay. Oh my God. The genetic genealogy database terms of service must be adhered to. Genealogy databases are provided by independent vendors. Independent vendors and the uploaded genetic profiles are used with informed consent with members of the public. Well, they should be, but they aren't always. Hence, their trust must be maintained. Oy. Yeah, again, a lot of this is echoed in the DOJ. Outsource, wait. Outsource contracts with vendor laboratories, laboratory generating S&P profiles with genotyping or sequencing-based workflows, and the genealogist, see, participating, because again, they're separate people. They have to be approved by the FIG. Qualifications of vendor laboratories will be determined by the FIG-RA. Vendor laboratories shall provide documentation regarding their quality assurance systems upon request. They should be doing the things that they are doing. Right, qualifications. Well, that's, still working on getting that up to speed. Yeah, like we heard this from keep going back and forth between Gabrielle and Gabriel. I don't know which one it is, but that when she started, it was all just your self-taught. You know what I mean? Like, but that's changing recently. What else we got on here? Mike Baker article. I don't know. This is just listing different articles. Is that last page? That's last page. Okay. What are you guys saying in the chat? I'm behind again. Oh, Flash with the fried chicken. Let's just do this. Yeah. The fried chicken and the cheesy potatoes. Oh, thank you, Flash. Thank you for helping people learn how to use the Discord. I appreciate you so much. Yeah, you got it. We will help you through it. No squirrel left behind, as I will say. It's a little bit different at first because it's not quite as intuitive, in my opinion, as maybe other things. But once you learn how to use it, honestly, it is such a great resource. You can, like, for anyone who's not familiar with the Discord, like, you can share links, you can share videos. You can voice call, you can video call, it has no limits and everything is free. You can like have a video call with like a bunch of people. You can like do all kinds of stuff. It's really, in my opinion, it kind of, I think is going to be the future of replacing like all the other bullshit. And the thing that I love about it is it's not about self-promotion because you don't have like a profile, right? It's not like, hey, look at me, blah, 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 it's like literally all it is just communicating with like a group of people that are approved for the Discord, right? Yeah, so I really think Discord is great. I thought it was confusing at first. And then once I learned how to use it, I was like, that is amazing. Like, because you can tag people, people can remain anonymous if they want, or they can use their YouTube name. And like, you can use all the, honestly, one of my favorite things, you can use all the Nightbot commands. And y'all know how I love Nightbot more than anything. So yeah, and so you go to the different threads and it has different categories. There's actually a thread for Bryan Kohberger too, if you want to post stuff in there, or you can post stuff in scroll chat. There's also a food thread. I forget what it's called. There's a food thread. There's all kinds of stuff on there. Right. Yeah, she's the one who signed off on the invoice. Like I actually, it's funny because I noticed that before I had any reference for that name, right? Like when I first saw the invoice here, unshare, reshare, unshare, reshare. Okay. So like, because there's not much on this document, maybe, right? I was like, oh, that name, there's a name. I was like, huh. Right. So I remembered that name. Just funny. What happens if I click that? Oh, weird. Probably don't want to be on the hook for $9,500. So we'll just look out of that. I didn't think anything would happen. I just clicked it just to see. By the way, I spent a lot of time on the Othram website, and like, it's funny because there's not a whole lot of information on there. So I don't know, but, okay, let me go back. So, okay, let me see, what else did I have on here? So did we finish this article? Oh no, we didn't even finish this article. We left off here where it's highlighted. Okay. Right. Suddenly the possible constitutional implications would no longer be about the DNA left at a crime scene and the rights of genealogy website customers, right? It would be under this potential scenario that he himself would have not consented. It's not clearly a vicarious claim because it's making him a claim for himself. The chances of that remain low. Even Kohberger previously submitted his DNA to a genealogy website. Most people use either Ancestry.com or 23andMe, which law enforcement can't access and requires customers to use each company's proprietary testing kits. But other possibilities remain, he acknowledged. Kohberger could have downloaded his DNA profile from either service and then submitted it to GEDmatch or Family Tree DNA, but still not agreed to allow law enforcement to use it in its investigations. I mean, or he could have agreed to let them use it, although then you wouldn't have any, there'd be nothing to complain about, really, if that's the case. It's never happened in any case that I'm aware of. And that's what I've been saying, right? Like I said earlier, I was like, it's going to happen. It's just a matter of time, right? But it just hadn't happened yet, which is wild. It's wild. It's never happened in any case. Wow. We've had cases where there's a sibling or parents or something, but no one that I know in the field has ever encountered a violent criminal who was so stupid. Well, that's not very nice, as to upload their own DNA. But again, take stupid out of it. That's not very fair, right? But any person, stupid or not stupid, if they opt out, they should feel like they're all good, right? And yet one other scenario, Kohberger could have originally sent his DNA to MyHeritage to produce a DNA profile. FBI investigators then would have to then would have had to upload the crime scene DNA to the website while conducting an IGG review against the terms of service, but as the federal agency has previously been known to do, and then landed on the exact match for the suspect. I think it would be unethical. It would be something that I would strongly urge them not to do, but it's not illegal. Yup. For them to access the MyHeritage database if that's indeed what happened. That'd be funny. So that's what I used MyHeritage. Shout out to MyHeritage. It might be the devil's limit. It raised the question, is the FBI operating in the gray area? Well, I don't think the FBI is doing it. Again, sorry, I had asked the question. I forgot to answer the question. And the thing that we read about the ISPS, whatever the fuck it was called, and their agreement with Othram, remember, I was like, keep an eye out for where it says that they use the FBI. Well, it wasn't in there. So I'm just circling back to that to note it in no point said using the FBI in that whole protocol with their agreement. So yeah. Okay, so that's the end of that article, basically. Okay. I don't know what this means. You deleted what now? So to enter a sample to quote CODIS. Yeah, I don't think I've seen anything about the sheath sample being incomplete. I just thought it wasn't a match because whoever left the DNA there wasn't already a convicted violent offender. I don't know. Like, did I say something that sounds like a phrase from one of those places? I'm from North Carolina. But I don't know if I said something that makes you think that I'm from Wisconsin or Missouri or Oklahoma. I don't know. Do those three states have anything in common? Okay, so all right, let me see. What else did I need to do over here on these documents? We did that one. The DoorDash is interesting. What is this one? Oh, that's the declaration. Okay, so this one's interesting. This is back to the search warrants, right? Applications for search warrant. February 10th, 2023. DoorDash. I mean, these are all ICAR. And here we have Maori again. Obtained a search warrant for DoorDash on 12/6. On 12/6. On 12/7, he received an email from DoorDash which contained the requested information, which of course doesn't say what that information is. An inventory was prepared for all the items received. Oh, okay. What do we got here? Oh my God, this is so blank. Let us see. That's really funny to me. 6th floor. I've literally never seen, can it highlight? Come on, Adobe. I've literally never seen this on an address. Oh my God, Adobe is being stupid. There. I literally, like, that's hilarious. How's that an address? I've literally never seen that. Aha, here we go. Okay, here we go. This is what I was looking for. All right. So all information in your possession or control related to sales, deliveries, purchases, and or transactions made to 1122 King Road. Date and time of sales, date and time of deliveries, purchases, and or transactions, name and identification of the driver, a full description of the vehicles used, any and all communications. So, I mean, I suppose this could have been because, you know, the DoorDash delivery. Wow, that's a lot of caps. But the thing that was interesting, where was it with the date? December 6th. So remember in the calendar thing or timeline, right? December 16th, I want to say, let me look. Yes, December 16th. Correct me if I'm wrong. Was there anything earlier than that? December 16th would be the earliest thing that we know of, right? Of where they are on, like, following Kohberger, like they've zeroed in on him as a suspect, right? And that's because of the CVS in Pennsylvania. They've zeroed in on him as a suspect by then, December 16th. So is there anything earlier than that? But I mean, that alone though, right? That alone. It's like that's really quick, even if you go with like, they get the DNA, they get it extracted, they get it sequenced, they do the SNP thing, rushed through Othram, which took, you know, well, yeah, no, that was November, right? November 29th is that invoice. Well, I guess it's possible then. If they get that back on the 29th and they just pop it in on the database and it's like, you know, direct match. Well, then I guess that would be possible. But I mean, it's just fast. It's fast even if you get that lucky, right? That's what I'm thinking. Oh, you deleted Discord? Okay. So anyway, yeah, but do you guys know of anything else before the 16th? That's the earliest that I can think of. So, okay. Next up, I made a special swoop. We're going to do a swoop and then we're going to go to this spicy hearing. Now, the spicy hearing that we're going to watch is not very long, but it's very spicy. And it's the hearing directly before I started covering this case. Of course, I was following it, but I wasn't yet covering it. And there's a lot of really interesting pieces of information. By the way, did anyone place the quote in the thumbnail? The quote says, in quotations, there are a lot of issues in this case. Did anyone place that quote? Did anyone remember where it was from? So while you guys think about that, let's see our new swoop that I made today, rather. Brand new swoop-a-doop. Sorry. It's fun. It's fun. Should we maybe see it one more time? Just for fun. Okay. So now let me pull this up. Okie dokie.
We have a few things just to sort out today. The first thing I want to talk about is whether or not this hearing should be sealed. What's your position, Ms. Taylor?
Your Honor, this hearing should not be sealed.
Okay. Mr. Thompson? Ms. Jennings?
Your Honor, the state's prepared to do its argument today without actually talking about the specific request that we're trying to protect within the discovery request. And so as long as those specifics are not discussed or mentioned, then I think we can go forward with an open hearing today.
Okay. Are you comfortable with that, Ms. Taylor?
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing for. What I'm prepared to talk about is why should we seal this particular motion to compel that's set to be heard, and how much else is in the public record, and why there's no compelling reason to seal that, and why that violates Mr. Kohberger's constitutional rights. So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
It's the challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there, and so I just want, I hope that you can both honor that at this point, because
Great
down
question.
the line, maybe
Great question here about the door. Yeah, I don't know, right? That's why I found that interesting. That's why I found that noteworthy. Yeah, I thought that was interesting as well. You know, it does bring up a good question, right? That they had reason to need to go deeper into that. I don't know. You know, just interesting. Who is making shushing sounds? Are you, I don't know. I don't know who's making shushing sounds, but this hearing is very spicy, I will say. And there's, again, in light of what we've just been talking about, there's a lot here where you can see that people want to say more, but they feel like they can't. By people, I mean, especially Ann Taylor and Judge. I feel like they're like wanting to say things, but they're like, you know, I don't know. You guys will see.
some things do have to discuss, we need to discuss very specifically that maybe both sides don't want that out in the public, because it is a fair trial goal here. And if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, gets more complicated. And maybe
Was that this hearing? So I watched this hearing this morning and I didn't hear the shushing. But also I was tending to my orchids while I was listening to it. So I may have like gone in the kitchen to get some more water or something and missed the shush. But I listened to it twice because of the fact that I was, you know, tending to my orchids while I was, anyway.
prejudicial.
But
one
yeah,
or the other.
we won't miss it this time, or I won't.
So I guess at this point, we'll keep this open, but be careful. I mean, I've read everything, so I know what's sort of out there and what you're concerned about. And some of those materials or potential evidence could be prejudicial to the state, or it could be prejudicial to Mr. Kohberger. So my job is to try to keep on a balance here, a neutral balance, where when we get to the trial, if we ever get there,
accurate,
that it'll be fair, and we'll have been determined in advance. Okay, so keep it open today. If something comes up and we need to close it down for a period of time to discuss a particular situation, then we can do that. Okay, so it really, I think at this point, it's the state's motion to close the hearing completely on May 14th. I believe, I'm not incorrect, that you both have stipulated to closing May 16th, which is related to the IGG.
Your Honor, our position is that's the only part that should be closed, and that's because we want to talk about the content of the court's, the materials protected by the court's order, and so that one's appropriate to close.
Okay. Okay, I think I'm on the same page. Great. Okay, Ms. Jennings.
Thank you, Judge. So, Judge, the applicable authority today in determining whether or not we should close the May 14th hearing is Idaho Administrative Court Rule 32 and Idaho Code 74-124.
Like, no shocker there. It's always ICAR 32.
Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the motion to close the hearing, the state
That's very interesting, you guys. So American Princess, do you usually follow civil trials? And Stevie B, so does this mean that you've never watched a trial? I can't even wrap my head around that. That is amazing. Wow. Wow. Well, I am very happy for everyone who's following a trial, whether it's your first trial or your 100th trial. I think it makes us better people. I've gone on and on about it, so I won't bore you guys with it now. But I think following cases and following trials and watching trials gavel to gavel is extremely valuable for us as humans. And yeah.
Those interests. And ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing. Feel confident
I
that when
mean,
the court does this,
LOL though, like, haha, very like she's concerned about the defendant's rights. When the defendant is like, hey, this violates my rights to make it closed, she's like, I'm protecting his rights by wanting it to be closed. That's just,
same balancing test, it'll come to the same conclusion.
that is incredible.
For the record, since the beginning of this case,
that floors me. That floors me. Is there anyone else here who's never watched a trial? I don't even know how to wrap my head around that. Like that is like, I mean, in a good way, like, because this will be y'all's first trial, unless you follow something else. So American Princess usually follows. So interesting. Huh. Well, I'm glad for everyone again who's here, or who's just following this case and following trials, whether it's your first trial or not your first trial. Debt be heard. Yep. For anyone who likes civil trials, did anyone here watch J Hatch v. Kowalski? Or sorry, Kowalski v. J Hatch? You get it right. Kowalski v. J Hatch. I've watched a lot of trials gavel to gavel. I've covered a lot of trials gavel to gavel. Some of them more than once. But I mean, I saw my first gavel to gavel trial back a couple of years ago and never went back. I don't even watch TV. I just watch trials and shit about trials and court documents and pretty much, or stuff related to music. But Daryl Brooks. Well, here's the thing is that, and that makes sense. I understand that. That's like a certain brain, an analytical brain. I think constitutional law is very interesting and as well. But I'll tell you what, there's nothing like a trial, I will say. Because the theater and the drama, I mean, not that that's the point, but like, it's way more than what you would think probably. Like, things happen in trial. It's like more compelling than anything, and especially especially when you see justice being done correctly. But then also when you see it not being done correctly, that's equally as important, right? Because we can make a difference, right? We've already seen that where people can have an influence on things in a positive way, right? OJ, that's really funny. Yeah, I mean, there's a lot of crazy cases, my favorite trial, y'all, is Murdoch. And tomorrow I'm going to be covering for his appeal. I don't think anyone's covered the appeal, like the whole thing. I'm going to cover the entire thing. It's 132 pages. So tomorrow will be part 1. But Murdoch is my favorite trial. And but trials are the best, I think.
Attachments detailing the specific discovery request have been filed under seal. In line with this, on April 4th of 2024, just about a month ago, the state and defense filed a stipulated motion to file all future attachments under seal. Today, we're specifically discussing the defendant's 4th and 5th motion to compel discovery. Concurrent with the defendant's 4th motion to compel discovery, the defendant motioned the court that the details be filed under seal, citing Rule 32. Concurrent with the 5th motion to compel discovery, both parties stipulated to filing the details under seal, citing Rule 32 as well as Idaho Code 74-124. So the state followed course. We have filed all of our responses under seal and then filed this motion to close the hearing to discuss those previously sealed details. Now the defense is taking a contradictory position and asking the court to ignore all the previous filings. And this is just entirely inconsistent. To be clear, the state has nothing to hide. However, it's crucial that we protect, as we have been trying, the integrity of this case, and that we protect, ultimately, the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that, for a defense's 4th motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code 74-124. 104 subsection 2.
So by the way, speaking of Casey Anthony, I'm the first and only person on YouTube to be covering it gavel to gavel. I'm currently covering it gavel to gavel. We are on day 20. Nobody had covered it, so I'm doing it. So for anyone who's curious, feel free to join. I have a playlist for all the different trials that I have covered, am covering, etc. And glad you're here, Heather. Right, Flash is so true. And Flash, why are you not asleep yet? We'll make a trial nerd out of you yet. Yeah, absolutely. Yeah. I mean, I'm really holding my tongue because like I could very easily go off on all different scroll tangents, especially. I mean, I could probably do a one-woman show reenacting the entire Murdoch trial. Like, not even joking. The only difficulty would be getting all the accents correct. But yeah. I'm just here. We'll do this real quick. We'll do this instead real quick because better than me trying to do impressions. We'll just do this real quick. Hold on. I've got Judge Newman.
Bring the jury. Bring the jury.
And then I've got the classics. Let's see.
Hey, he's got a bird in his mouth.
It's a chicken.
It's a guinea.
Literally, you can hear the birds squawking in the background. That's literally from the trial. I clipped those. And there are, of course, corresponding Nightbot commands as well for them. So, you know.
What they specify as subparts B through N.
We love you,
All
Flutter.
of those items discuss evidence related to this investigation, of which disclosure would 1, interfere with enforcement proceedings pursuant to 74-124 subsection A, deprive the defendant a right to a fair trial and the state, subject to 74-124 subsection B and Rule 32 subsection E. And it would disclose investigative techniques or procedures which are exempt pursuant to 74-124 subsection E. For defense.
You know, that's the thing. Now it makes so much sense, right? Because like I've covered this ICAR in depth, right? And the thing is that the ICAR has this blanket thing about and it's been in like all the documents. I'm just now thinking about the different context, right? About like exposing investigative techniques. It's like, how weaselly is that though? Like if the investigative technique is like they got lucky because they just like got a direct match, and it's like that's not even a technique. That's just luck. You know what I mean? Like that's some weasel shit right there. Hiding behind the ICAR.
That's its fifth motion to compel. Item 1, subparts A through J, all deal with the investigation. All would be exempt pursuant to the same authority just cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy, subject to 74-104 subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person, exempt under Rule 32 I2A.
I don't know what Jeff. I don't know if you're talking to me or what. I don't know who Jeff H is. I'm trying to think. Maybe there's been a Jeff H. Maybe, I don't know.
Or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32 subsection
We're
3.
glad you're here. We're glad you're all here.
Subpart N through O is exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, subpart A, names a private business and is exempt under the previously cited authority. Item 2, subpart B through L deals with the investigation, again exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives.
The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in media. The defendant will get his day in court.
It's so unusual, right? Because like this never happens. Like it's always the other way around. Well, not always, but typically, right? I mean, it's just odd when the state is like, we don't want it to be public, and then the defense is like, we want it to be public. You know what I mean? Just odd. Yeah, I don't know who Jeff is, but Jeff, if you're watching, you know, everybody's welcome here with the Scroll Crew. For anyone who missed it, we even had Uncivil Law here recently on a Shannon Gardner stream. That was like maybe 2 weeks ago. Chilling in the stream. I almost fell over. It was fun.
And the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence.
Then he's not welcome.
Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's fourth and fifth motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you. May 3rd might be a little quick.
Well, Your Honor,
Mark?
The next
right, but our motion was filed over a week ago.
Right.
So everyone's been on notice of what the state was asking for.
Okay, thank you. Thank you, Ms. Dan.
looks like there's some
Taylor?
Thank you, Judge.
looks like there's some mixed opinions about Jeff. I don't know anything about Jeff, but it's interesting. You know, I am the type of person who normally I think people are generally good. Like I'm sure I'd probably, if I knew Jeff, I'd probably be sticking up for him. Just saying. So
Our discovery requests have been filed for months
let me
and
update.
they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Can I just add, because I've read through all of the fourth and fifth, and it's, I mean, some of the information, it seems anyway, I mean, it's hard to know, okay, but it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
I would say the court is maybe in part right, but there's a lot of other parts to those fourth and fifth, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 14th about what they mean and some of the ins and outs that go into play with those. But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we file those under seal for expediency and saying, this is exactly what we want from discovery. If a court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we file those under seal, and for the reasons outlined in Idaho Court Administrative Rule 32.
Did you already do it? I didn't hear
So
it.
what we're talking about now is a public.
I didn't hear it. Did she do it already? I was listening for the shish. Did it happen already?
public hearing. When the state has decided
Okay.
to not give us information or to drag their feet on giving us information, we're talking about a public hearing where we have a right to be in the public eye, a public hearing. Bryan's the one with the right. It's his Sixth Amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho and the backdrop of his Sixth Amendment right to a public trial in the United States Constitution in Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases, State versus Kimbley and State versus Olivine, and they refer the court to Waller versus Georgia, and that is at 467 U.S. 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest.
Okay, 19 minutes. Yeah, so we're not there yet. We're at like 17 minutes. Thank you, Heather. Okay, yeah, that makes sense. I mean, because what I'm watching for too, since you guys said it's hard to hear, is like some of the time you can tell she's like facing away and like right now she's talking to Santa, you know.
That the hearing should be closed. In this case, in this hearing, that's not what's happening. The court would look at Bryan's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider that this isn't the state trying to protect Bryan's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel, are things that are outlined in the probable cause affidavit.
That you video. I mean, I couldn't agree more, but like also it looked kind of like she was laughing there a little bit, but it's hard to tell because they just kind of look like blurs. But yeah, the question, like, what is the state trying to hide? But I don't think it's the shush yet. I could be wrong.
It has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context, but that's what they're doing. When they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us, that is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IGG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. Mm-hmm. And that had information that was negative about Mr. Kohberger in it. So that's out there in the public. But that order was to protect information, the IGG information, that they say details how the state got to Bryan in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor.
So did she do the shush? The shush is supposed to be to Miss Taylor, right? Not to Mr. Thompson? Okay, we haven't missed it yet. Okay.
Is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Bryan's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents are filed under seal, that's fine. Those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial really ignores the public nature of this case. It really ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
Thank you, Ms. Taylor. You know, I don't know where did it stop though. I mean, if we start pulling out all the potential evidence for the trial, before the trial, then does the state get to respond to that? And that's where does it start? I mean, it or stop. It just is a roll of that. And so either side, okay, that it sends to the public that it is not, you don't get the context. They don't have the context.
Sorry, I didn't hear the shush yet, but you know, that's I remember, if I recall correctly, that was the first time she said something about him being innocent. I remember there's a much discussion, much ado on the YouTube sphere about that. And you know, I don't know. I don't know. Sometimes people maybe, I don't know, get kind of all up in a ruckus about things or whatever you want to say. I didn't make too much of that, you know. It's really, you know, pretty standard, I think, for defense attorneys. I mean, not always, you know, they may not have to say innocent. But the thing is that here, in this hearing especially, she's making a lot of arguments that I think a lot of them are not meant for the judge, but they're meant for the public, right? Why do I say that? Because she's talking about the public. She wants the public to see. The public deserves to know, right? It's not just Bryan Kohberger's interest, it's the public's interest. And here she's really, you know, making strong arguments about things that for people who are watching this, right, we will all agree with her, whether you think he's guilty or innocent or not guilty or whatever, right? Hopefully you haven't formed an opinion until the trial. But anyway, whatever you think, if you're watching it, you want to be able to see the hearings and you want to be able to see the trial. So no matter what, when she makes that argument, right, especially when the state is saying close it, right, you see what I mean? She's getting people to see it their way. And I mean that, you know, just like the defense's way, right? Like to like, she could, I don't want to say win people over. That's not the exact thing I mean, but you know, it's just sort of like, especially because a lot of people say horrible things about her, and really any defense attorney, that's, people just do that. And they're talking shit about her, and, you know, she might receive death threats. I know there's other attorneys that do, defense attorneys, you know. And so it's not a bad thing for them to be like, we're on the side of the public. We're on the side of the people, you know, like, I don't know. So because no people in the public, right? People don't like it when the state is like, or the government or whatever is like, or for people don't like it when any agency, doesn't matter what it is, right, is trying to hide things from them, right? Everybody wants transparency. So I don't know. So I think that it was a good time for her to say that, just because like there might be people who were listening to her that weren't listening to her before, if that makes sense. That's just my kind of take on it. Flash fan being awesome and wanting to support everybody. Yeah, let me know, y'all. And also, you can put links to those, not here because YouTube won't let you do it, but you can put links in the Discord as well. Right, the perception. So, and the thing, I've said it before and I'll say it again, like, she is a defense attorney through and through. Like the way that she gestures to him and puts her arm on his shoulder and treats him with such humanity and dignity. I mean, that's one of those things. It's like, you can't train that into a person, right? The compassion. It's not just like saying innocent until proven guilty. It's like, she truly believes it. And that is a true defense attorney. And I would say that someone else who I think has that is Jose Baez. It's like they could only be defense attorneys. Like they are just, it is like in their, speaking of DNA, it's like it's in their DNA and like they truly believe it. And it's just really important. And I really admire them for that.
The public, you have the context. You want more context. I get that. But it's really difficult to just open that up and talk about particular issues in the case without
I agree.
talking about the
I agree.
entirety of the case. And that's what trials are for. I mean, I totally understand that Mr. Kohberger has a constitutional right to a public trial, but having a hearing is not a trial. That's something different. And so that's why, that's where the balancing comes to, if you want to answer it.
I do, Judge. The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming. That
was one of the other reasons why I thought this was especially relevant this hearing, right? Because the motions to suppress just happened recently. And the
hearings in public. The state has dropped bits of information with different filings they've made all throughout the way. This can't be done in private. It just can't.
I would say both sides have said in their motions or their briefs that they've disclosed, certain things. And it's a change, see, that because both sides have agreed to seal a lot of these issues of evidence in the discovery. And so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like, this isn't about the discovery, this is about the hearing.
Your Honor, those are discovery documents, and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about. And these are about...
They're making an important point that the hearings that they are wanting to close are the ones, well, we didn't cover both of them. Well, I have covered both of them, but we just recently covered again the one on the 30th, right? Because they have the hearings on the 23rd and the 30th. And like I said, if we want to go back, I've got it saved. If you guys want to go over the hearing on the 23rd, we can totally do that with Detective Mallory. I actually watched that also this morning, and it was kind of a lot of the same of Brett Payne, where it's like, I don't know, I don't recall. I mean, it's just really frustrating, to be honest with you. But yeah, it is crazy to think that they, the state is arguing to have those closed. I mean, how the hell do they think that's going to happen? So yeah, I mean, I don't have any mods, so I mean, that's probably true. Like, I guess that means I could put a link, but yeah, I don't have any mods. Must be able to. So on the way it works, right? If you're a mod, you're given different permissions that the regular YouTube won't allow. So that would make sense. Okay. Well, if you guys want to watch that, we can totally watch that as well. Right. Thank you, Flash fan. Heather mods at like 10 channels. Yeah. Well, you and Flash have that in common. Flash also mods to mods a bunch of channels as well. But yeah, I mean, totally agree with you here. I mean, I think transparency is the way to go. Y'all know that. So, so yeah, so we can totally watch the May 23rd hearing, for sure. Yeah.
Things that are in the state's possession or control.
I mean, I haven't heard the shush yet, and y'all didn't say I missed it. So, I'm listening for it.
We want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation. It's not any different at all. Sealing the documents, I think that needs to continue to happen. That there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine. And I think they're different because they're documents that are going to sit in the public record they're different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve. Public has a right to see how its business is carried out. My interest is Bryan's right. But I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 from the public eye. All of a sudden we get to 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider too how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public.
So I feel like a good opportunity for the shush might have happened. I don't know if it happened or not, but let me just back it up a second because
we've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public has a right to see, and Bryan has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no change in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32 subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Thank you, Ms. Taylor. Response, Ms. Jennings?
Yes, Your Honor. Ms. Taylor's argument, and multiple completely false narratives are the exact reason why this hearing should be closed. Yes, defense has a right to a public trial, but that is not the right to having all hearings open to the public. The court's right. There will be a day for this, and that is the trial. But we shouldn't be discussing all the evidence that we're going to hear at trial prior to that. There's no right to try this case in the media.
That's why this hearing is so bizarre, because this is really not normal. It's like, it's almost like this entire thing is for the media, for the public, right? It's almost like a way that they can get around the gag order, because they're both arguing like, it almost seems like it's a TV show or something. Do you guys see what I mean? Like, this is not typical, like not typical at all. Especially because like the back and forth is so rapid. Like this is not normally how it goes. Those of y'all who are trial watchers, this is just very unusual. But that's part of why I wanted to watch it, because it's like, what the hell is happening, you know? Yeah, exactly.
The case law that the defense relies upon has not extended this balancing test to these types of hearings. The hearings are about, the cases are about trial. And yes, they extended it to a suppression hearing, which was so interrelated to the trial. Waller v. Georgia primarily stands for the proposition that any closure gives you this balancing test. We just went through the balancing test, and the state gave you the reasons for why this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding
the way that like she's like personally offended and stuff. Like, it's just so funny when this happens, right? Like when you'll see this happen in trials, right? Where the attorneys start to just take things personally and go back and forth. It's, you know, it's part of why I love it, right? But like, you know, eventually they'll get yelled at by the judge, and that's one of the best parts, you know, where they get scolded, you know, children, come on, children, behave, you know, all that, you know, approach the bench.
motions to compel. However, at that hearing, this is your order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. We discussed one request, and it had to do with training records. That is not what we're contemplating discussing at this hearing on the 14th. I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
I literally was about to say, Flash, you need to go to bed. You read my mind. I was just about to say that. So please go to sleep. We love you. Good night. Hopefully we'll see you tomorrow. You're the best. And hopefully you can also have some of your favorite fried chicken soon. Are y'all getting close to finished with all your holiday preparations? I still have to wrap presents. June 27th, 2023. June 27th, 2023. June 27th, 2023. Was that open? I can't remember. Oh, that's so funny. Somebody else was talking about Raising Cane's. Oh, it was Aaron from Minnesota was talking about Raising Cane's. I've never heard of that. That's so funny. Well, that's good. I'm glad you had Raising Cane's, because she was talking about it one day and said it was really good, like a classic. So I'm happy for you though. That's awesome.
Thank you. Want to respond to any on that, Ms. Taylor?
Yeah, we're back to the.
Well, Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in us receiving documents that the court had a protective order on, and we can't even share with our investigators that come to court with us. And we've abided by that, and we understand that. But the entire hearing leading up to that was done in the public eye. In that particular hearing, they talked a lot about DNA results on a knife sheet. That I'm sure benefited the state to have that in the public eye. What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names. I can talk about records that exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected.
Isn't it the worst though when you have a regular place you go to and then that place just goes down the tubes? Like that's like the worst.
By the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of such.
That's the thing.
That's super audible. That's super audible. Let's listen again because we've built it up all this way. That's super audible, but it sounds weird. That sounds weird though. It doesn't sound like shh. Hold on. Let's listen again. Let me put it on normal speed. Normal speed time. Okay.
About the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of such.
That's the thing.
That is odd. That's odd. And now that I hear it, I think I did actually hear that when I was listening to it in the background and as I was taking care of my orchids. I think I did hear it and I was like, what's that? But I didn't put, it just didn't register because like that's not what I pictured. That I pictured like a shh, you know? It's more like a shush or maybe it's a hush, but it's just it's weird.
Cell tower information and the things that they have not given us, the drive test information, the verification of such.
That's the thing.
Odd. Like, is that like Tourette's or something? Because it's very like what? I mean, you can because Aunt Taylor looks at her, you know it's her saying it, but it's just very like it's weird because Miss Jennings doesn't look over at her. I don't know. Do you guys see what I mean? Like, it's weird. I mean, I'm surprised he didn't say Flash. Aren't you supposed to be asleep? I'm surprised he didn't say. It's odd though, man. I could see the judge. There's not like a hard G. Judge. I guess you could kind of see it as a judge. You know, I wonder, there's been one time where we actually benefited listening to something on slower speed. Let's just try that for fun and see. I think it was when we were listening to Judge Bev, something with Judge Bev and Karen Reed. Let's just see.
the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of
Shush.
The,
Yeah, that sounds like shush. It's just very odd, though. Isn't it odd, guys? It's just odd. She's going to laugh with Santa. Wow. Oddness, though. Like, okay.
that's the thing. I don't want to talk about those particularly. And I guess I'm reminded, okay, in your comment about the IGG, because once again, you know, I'm in this position where I have to make decisions blindly to some degree, and that's what the case.
That seems like a Tourette's moment. You know, here, you guys want to see something funny? I made this clip and I haven't even played this yet. Let me show you guys something funny. I call this from the Casey Anthony trial. Let me just show you. It's short. It's like 10 seconds or less, but it's really funny. Mr. Ashton, who's now a judge. Well, he might not be for very long, but anyway, it's where is it? It's his, I call it his schizophrenic moment. It's really fucking funny. Oh, I have this one.
Did
Hold
you
on.
encrypt them? What are we, the CIA? I don't even know what that is.
Hold on, let me pull it up. It's really fucking funny though. Like just thinking about like, just because I'm like thinking, is she having like a Tourette's moment? And so there's something even more obvious, and that's the schizophrenic moment, which we're going to see here in just a second. It's really funny, I promise. Y'all are going to be like, what?
You were asked about Dr. Voss. And,
oh my God.
You were asked about
oh my God.
Air samples. Have you ever heard of any case where air samples were used in a forensic setting?
Objection. Relevant expertise.
Let's watch it one more time.
You were asked about Dr. Voss. And,
oh my God.
You were asked about
oh my God.
Air samples. Have you ever heard of any case where air samples were used in a forensic setting?
Objection. Relevant expertise.
That's why I'm like, is this like a Tourette's moment? Like versus like that. It's like a schizophrenic moment. That's what I've just nicknamed it in my own mind. Mr. Ashton's schizophrenic moment. Pretty fucking funny. That's funny. Yeah, what's that from? Catch Me Outside. How about that? What's that from? Is that from like Bad Girls Club or something? Okay, good night for real, Flash. We love you. I mean, I don't know what Hitler would do. Oh, is it from Dr. Phil? Okay. Yeah. I think I know what you're talking about, but it's similar vibe, I would say, though. Similar vibe, right? I would say. Sorry.
Case with the IGG. I mean, I had to go through all of that information, and then I provided most of the information to you, okay, to the defense, so that you could evaluate that. I feel that the same way about all the. I mean, there's a lot of stuff, okay, that you're arguing about.
Get ready for the quote.
And the state is arguing about, and I think it's complicated to just open that up. I think that, you know, maybe we could go through a closed hearing and then open up what you feel needs to be opened up. But I can't make that decision in the you know, abstract. So that's my worry, because I went through all this last night again, and I thought, how do we really fairly deal with each one of those issues? There are a lot of issues.
I agree with you. There are a lot of issues, John. I would ask you to look at the probable cause affidavit and read the parts where they talk about relying on FBI agents.
He says it again later. That's what's so interesting, because again, I was listening to this and I was like, I heard him say there are a lot of issues, and he says it like twice, and then he says it again later, and he says there's a lot of issues in this case. And I was like, this is interesting because you don't ever hear a judge say this.
Agents and the cast report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas. Who's just taken to the FBI. I mean, it's really difficult to get information from the FBI. You know that. They know that. I know that. We have we have to jump through a bunch of hoops to get particular information from the FBI. That is not the state's.
So again, this echoes what we were talking about earlier, right? With the IGG, quote unquote. This is exactly it, right? You know, this is exactly what I was saying, where let me play this again for you guys. What he's saying was articulating what I was trying to articulate earlier.
Yeah. I mean, it's really difficult to get information from the FBI. You know that. They know that. I know that. We have we have to jump through a bunch of hoops to get particular information from the FBI. That is not the state's issue, although maybe it should have happened 6 months ago.
That's the state's issue.
I understand that. But that is one of the things that, I mean, we can maybe address that today.
It's kind of what I'm saying, right? Is like the state by like, again, if they wanted to make it like the involvement of the FBI, right, as it pertains to the IGG, it's like something they can almost in a way potentially, not just this state, any state, right? You can hide behind it, right? Because again, like he just said, and we know that's the case, right? Like that's the whole thing. When you involve them, now you've got like this whole plausible deniability. And again, like I was giving that example earlier of like the factory, right? So, you know, yeah, hopefully that makes sense.
Too. I don't think, thinking that you don't have an objection to you sign the subpoenas.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I can sign that. I can sign that today.
You can sign that. You can sign that. Anything.
Heather, I think you were here kind of late, but that's what I was saying. You know, we delved way deep into the IGG, and that's what I was kind of suggesting earlier, you know, hypothetically that it's the only thing that makes sense. Going through all of the documents. So yeah.
Anything you need to sign to get us the things we want, please sign.
I'm with you. I'm trying to do that. And, you know, from what I've seen, I mean, I think the state is trying to do that. I know that it's not satisfactory from your position, but there's a lot of issues in this case.
And Your Honor, that's really a lot of what we're going to talk about on the 14th is the timing of these things, not the full content of what we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do.
Watch this, right? Watch this, guys. I know you guys have seen this before, but just I want to point something out. Look at the state. Bill Thompson's not even made eye contact or like looked over, by the way, towards Ann or even towards Judge. He's just kind of looking over there to the side, you know. But the thing is like, listen to this exchange and how it's like everybody's really in the dark for the most part, with the exception of the two over there in silence. You know, it's kind of like the villains in a Disney movie or something. You know,
and there's a lot of issues in this case.
And Your Honor,
there's the actual quote in the thumbnail. Again, like I said, isn't that crazy how many times he says that?
A lot of what we're going to talk about on the 14th is the timing of these things, not the full content of what we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do.
Feels weird to me.
And when we make a request and months later, you're asked to sign the order so that maybe we can finally get that information, that timing part is important.
I know you're asking Heather, but I think Frank's is the IGG.
For the public to know. That's not the content. I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial. That is fair game for the public, and that is something Bryan has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for 1.5 years now it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done with this issue.
Okay, thank you.
And the way,
I mean, are you expecting to make,
interesting, right?
make the decision?
Pause. Interesting that the state is now being really quiet, because remember what happened earlier? Remember how I said, like, this is really unusual. There's like a lot of back and forth, da 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 da, you know. And now, and let me put it on normal speed so we can really appreciate that, because it's weird because she sits down and the state just sits there in stony silence, you know. Okay.
Or ask when we're done with this issue.
Okay, thank you.
Odd. Very odd. You know, and the other thing, by the way, you know, look at, you know, here's the thing. I always say, I'll put on my behavior panel hat. I always say that because I don't really like pay attention to body language or whatever, right? But I always say it whenever I'm going to comment on something that I feel like they would say. And I feel like they would say she's steepling. Look at her hands, people. That is that's the steepling. Let's see, how long has she been doing that move? Because she's being, you know, the silence and the steepling, the silent steeple, as we shall say. She's still doing it. Holy fuck. Let me back it up a little further. When does, okay.
We'll sign the order so that maybe we can finally get that information. That timing part is important for the public to know. That's not the content. I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial.
Put two and two together, right? You know, yeah. No wonder when I said it was something that gave me a vibe of like in a Disney movie, like the villains. No wonder, because you know what they'll always say, again, on the behavior panel, but like the steepling, they actually always give the example of Dr. Evil from Austin Powers. It's like what the villains do in all the movies, right? Is the steepling. So that's really funny, right? Because I thought of the Disney thing before I noticed the hands, at least consciously. So
that is fair game for the public, and that is something Bryan has an interest in having public.
There it is.
So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for 1.5 years now, it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done with this issue.
Okay, thank you.
Very weird. Very weird. Very weird. What do you guys think?
I mean,
just all in all, a very odd response. I mean, is she too busy like plotting someone's demise over there to respond, or like what's happening? Yeah, I know, right? I got that vibe as well. Right. Yeah. Okay. So Heather, I agree with you. Like I said, I think Frank's is about IGG and the motions. Right. The motions to suppress, each one is something different. Yeah. But the Frank's is IGG. Yeah, I agree. Oh, that's a good point. Well, okay, just thinking through this, okay, theoretically, bear with me. So he was just giving that as an example. I wouldn't say that that footnote was supposed to signal that he found something especially important. He was giving an example of something where they had mentioned something and then the exhibit was like some crazy hundreds of pages or hundreds of pictures or whatever, right? Where he was giving an example of something where he would need it to be narrowed down. So I wouldn't read into that as like he thinks that's especially important. But but you could also say, well, the fact that the vehicle is mentioned at all. Well, here's what I would say to that. Because the timing, and I'm not going to go on a scroll tangent and go pull up all the documents again. Plus, some of you guys probably have the dates memorized. The changing of the vehicle years, right? Depending on the timeline, it could be something that's mentioned because they already by that point maybe had a return on the DNA in terms of like the direct, I don't know. I'm not going to go scroll tangenting and look into it because it just offering it as a suggestion, right? In other words, let me put it this way. It could be that that is related. I mean, it really is all related, right? And because remember, the whole thing is fruit of the poisonous tree, right? So everything is all intertwined with that, right? And it's all fruit of the poisonous tree being IGG, and that rhymes. So there you go. Right. The Santa freaking out about the survey and then fighting with the expert on the stand is when I decided to start covering this. Because I mean, again, I'd followed this from day one, but I was like, well, everyone's covering it. And like, I'm not going to be one of those people. But after that spicy ass hearing when Santa got really mad at the expert dude and they were like fighting, I was like, yep, there you go. I have to start covering this now. So yeah. Right. Correct, Heather. Yeah, you can file a motion to suppress without a Franks. Yep. But a Franks is like a big motion to suppress. Well, it can be. It doesn't have to be, but it typically would be. Right. And I figured as much. That's why I even referenced that, the Austin Powers. Yep. So you picked up on the steepling as well. Right. Correct. Yeah, he wanted to make sure that they knew what he was looking for. Just like when he gave them that hint about, or not hint, but he was like, you went over the page limit, but I'll let you redo it. You know what I mean? Similar thing. Yeah, the Franks filing is IGG. Rolo seems to think he's in on a dating app. Have I confused anybody with what we're doing here? Right. I mean, I'll just say this I'll just reiterate this, right? Again, the standard for a Franks hearing, right? Law enforcement officers in an affidavit used to get a search warrant must have made a statement, either knowingly or intentionally false or with reckless disregard for the truth. That is the standard. So already you can throw out anything else. Again, like I mentioned, the fact that in the affidavit, it says November 29th is when they got the information about the license and the car and all that. And then in the hearing we just listened to, and we went through this over and over again to make sure, December 20th, right? December 20th. Right there, if you're going to say, okay, so either you're going to have to say either he was lying at the hearing in person, right? Or he was lying in the affidavit. That's why I asked the question to the chat, like, do you guys think he's being truthful in the hearing? Because if so, he's lying in the affidavit. That affidavit was used for everything, right? That's not even, you don't even have to worry about the car or the IG. I mean, technically, like that right there is a problem. Now, I don't know everything. Obviously, we don't know everything, but like, there's a reason she asked those questions, because she was like, something's fishy about the timeline. If they lied about a date, either knowingly or intentionally, or with reckless disregard for the truth in those dates in the affidavit, there's problems, right? So, right. Well, again, like I just said, you really, again, if you just look at, for example, that discrepancy with the dates, you don't even have to have the IGG, right? So there's that. But again, this is going to be for argument, and that's why they're going to have a hearing, because I think they're going to try to say what I've been saying, even before there was any thought of like, or recognition that Kohberger could have maybe submitted his own sample. What I've been saying is, and honestly, it's so funny because I found other articles. I didn't read all of them, but I found a lot of articles that said exactly what I've been saying, which is that it's like they're saying they used IGG without saying they used IGG. That's what I've been saying for like weeks now, where it's like they didn't use the letters, but like they're basically using the letters, right? They're hinting at it, blah, blah. It's like to give them plausible deniability. That's for argument, right? So like there's that. But also, if the way they got to him is because of a direct match, right? And that's because of using a genealogical database. And then, you see what it's going to have to be for argument, and again, the part of it is so tricky because the timeline's all fucked up. But the ins and outs of that timeline is where it could be, right? Again, the fruit of the poisonous tree, if that makes sense. So shout out to Need Some Z's. Glad you're here. I'm always on the late night train. I've had live streams. I'm trying to think of my longest one. I think almost 11 hours, but I've had many over 10 hours long. But I would say probably the vast majority, if you were like average them out, are over 7 hours probably. And usually late night, but sometimes not, sometimes other times. But I'm a night owl. And I'm not a big, I take squirrel naps, you know what I mean? I covered this. You may have missed it. And even though I was kind of addressing one of the comments that you gave me that actually spurred on, I was like, oh, that's interesting. Because he says I reviewed. It's in I've covered it. It's in the affidavit. When referencing November 29th in the affidavit, he says I reviewed. Personally, firsthand, I reviewed, point blank. I covered it. So I don't think that's possible. Like he says he says I, like, yeah, that was probably confusing the way I just said that, but yeah. So thank you, Heather's citing here. Motion to suppress all of it. Right. That's the fruit of the poisonous tree. So they're going through that. Yeah. Right. And again, that's where the direct match comes into play here. Right. That's the thing, right? Like it's not in any of the warrant. And so this is, like I said, this is why it's going to be for argument, because in other words, it should have been in a warrant and it wasn't, because the way potentially, if all has happened, right, the way it happened was not illegal. We covered this earlier. It's not illegal. It's not illegal, but it's exactly what the defense has been hinting at, which is there's certain constitutional concerns or, Fourth Amendment problems and whatnot, right? Because it's not illegal. Because there's no laws for it yet, unfortunately, unless you're in Maryland. So it's not illegal, unfortunately. So yeah, I just wanted to clarify that, because we covered that earlier tonight. I know not all of you guys were here, but it's not illegal, unfortunately, unless you're in Maryland. It violates the terms of service. It's not illegal because there's not a law against it. We covered all this earlier. We read a bunch on it. So yeah. It's against the terms of service. It's not illegal. I know it's awful. It's terrible, but it's not illegal yet unless you're in Maryland. And the only way it would is if there's a constitutional violation. That's what they're going to have to argue. Again, we read it in the things, like this has not happened before. That's why it was so powerful when they said, like, they had not seen this happen, where if this is what happened here, it hasn't happened yet where there's been a suspect who was a direct match in a database. Like, this is uncharted territory. I mean, even without that, this is uncharted territory, right? Again, the Wild West, they keep calling it things like that, So, and this is what I had said, right? But again, because of if there's a direct match and it was obtained, again, it's not illegally, but this would be, again, for argument, it's gonna, if something comes of it, it'll be bigger than this court, right? This is going to be, because what do I keep saying? There aren't laws yet, right? What's going to happen with stuff like this is either it's going to happen through the legislature, or some case is going to have to go all the way up to the US Supreme Court. Okay. And then it will become case law, and it's whatever happens first. This is going to have, let me just put it out. This is going to have to be worked out. This is going to have to, if he's the first person, if that's what happened, he won't be the last, and it will happen to somebody else. And this is going to have to be worked out. Whether it's, and the problem is it all goes slowly, right? The legislature branch goes slowly, but so does getting something to the US Supreme Court. It's anybody's guess as to what could happen first, right? But this is going to have to be dealt with. So y'all feel free to let me know what you think will happen first. Will it happen with the legislature, or will a case like this, maybe this case, potentially go all the way up to the Supreme Court? Because it is, if that, let me say it this way, okay? If that's what happened, right? The thing that they have in their favor for the defense is that this is a case of first impression. Entirely a case of first impression, because it's not happened before. In other words, this is where this would be for the Supreme Court, because they're going to have to go through, again, it's constitutional violations, right? And what does that mean? How do you reassess things when you have new things that come up, right? Every time a case gets before the Supreme Court, it's because there's the same set of laws that's been there, but some new set of facts is making you look at it differently. And the reason this happens, right, is because the way it works with case law is that when you are at any court level, let's say a trial court level, right, or even you have to go and look to the higher level courts for your mandatory binding authority. And the way that works is it has to be within your own jurisdiction from the next level up court or higher. And one of the key factors is, this is crucial, the case has to be on point. What do I mean by that? It has to have facts or circumstances that are substantially similar in order to address, because you've got different questions, right? You've got the legal questions, right? And then you've got the factual questions, right? So two different things. So in order for something to be on point, it has to be on point with those. It has to have the same legal questions that are being raised and similar enough facts. Now, not down to the detail, right? But similar enough. And it has to be within your jurisdiction. So when new case law is made, right, when you've got a prima facie case or there's new precedent, it's because something is new, right? Like there was something that the US Supreme Court just heard something recently that was really interesting, and it had to do with an enhancement for a violent weapon. And I can't remember exactly what it was, but it was really interesting because it seemed like, okay, this is run of the mill. And then there was something about it that was unique, that was different enough to get all the way to the Supreme Court. And it wasn't even about a conviction. It was about somebody was going to get maybe 5 years longer in prison, but it was an issue enough that needed to be settled by the US Supreme Court, made it all the way up there. And so, and it's because you just get a certain specific fact that's a little bit different, and it challenges the way you look at the law. And so you appeal it on up, and you see what I mean? And so these cases that come before something like the US Supreme Court, they're kind of really more theoretical, and it's very, very, very interesting to hear it being argued. And so, in other words, this issue, if this is what happened, is a perfect candidate. I mean, it is. I can't think of a better example. So, and that's also true, right? It was not an IGG tree, right? Correct. Yeah. Again, we've talked about that. So, and we did the DOJ rules. We did those. I mean, yeah. So I will just say, I have no idea what some of these things mean in the chat, but yeah, anyway, so I think that the answer here, guys, is bigger picture than things like SIRE or individual people or whatever. The issues here, if it is something like they let's just say that they used the back door, they violated terms of service, whether he was opted in or not opted in, right? Like, you know what I mean? But especially if he was opted out, if he did donate and there was a direct match, blah, blah. this is a case of first impression, and this is going to have legs and going on up because it's not been litigated. I mean, because even I read it, what was it, yesterday? It was in a document we covered, I think yesterday, where they said it was a case of first impression for Idaho, but it's also a case of first impression for the United States. So yet, Stevie, let me just explain this because I know this is your first trial. I'm glad I know that now. There's no law that prevents them from doing that. The way that a law will get made in terms of a statute is if there's something that happens through the legislature branch. However, there's also case law. Case law exists to fill in the gaps when there is not a statute or a rule, whether it be federal or in the state. When there's not already a rule or statute in place, that's where case law comes in. And case law gets made from cases like this. When something new happens that hasn't been decided on, and it's a potential constitutional violation, that type of issue actually is especially suited for the Supreme Court. That's one thing that they handle. That's what they do. Like, constitutional violations is one way that'll get you there quicker than anything else. Or civil rights violations. That's the whole point. So in essence, right, when there's case law, in a way it is law. It's not a law like a statute or a rule, but it is law in a sense that it is now mandatory binding authority on all the courts below it. And if you're talking about the U.S. Supreme Court, that's all courts. Okay. The way it works is every court level in the country is bound first by the U.S. Constitution and the U.S. Code. After that, it's the U.S. Supreme Court. Actually, not even after that. I think they're all tied for first place. And those are the only things that are binding on every court level in the country. U.S. Supreme Court case law is, again, it's as good as a law like a statute. It's not the same. It's just because it's not done through the legislative branch, right? Like, it's done through the judicial branch. So that's the difference. Like, an actual law has to be done through the legislative branch. So does that make sense? So yeah. Hopefully.
Are you expecting to make the decision right now? Maybe not.
Well, Judge, you should just make the decision to have the hearing open. And if I start to talk about content, then maybe you can talk about it then. I don't agree any part of it should be closed. I don't agree any part of the hearing should be closed. And I think you should make the decision now. We're 2 weeks away from this hearing.
Oh, 2 weeks? Is that right? 4 days?
We're less than 2 weeks. We're 12 days.
All right. Well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm going to close that here. Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you aren't getting what you want or what you've asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI and that we need to get that. I mean, those are all really complicated processes. And I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make a more informed decision. So I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it. But I need to dig in, and you all need to dig into exactly what is the problem with each one of these issues. All right. So let's talk about the schedule Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, and I'm not looking at it right now. You got another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will put an order out, schedule order for providing. I don't know if the state really knows what you do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And
Oh,
that means that maybe you don't have any
thank God, it could have fooled me. Prosecutor Santa's still alive. We haven't heard from him, I don't think, at all this hearing. But we got a yes, sir, out of him.
witnesses, expert reports, or exhibits at this point because you don't know what to expect. And this is related to the hearing on the 16th, right?
In the 14th, I'm not sure.
Okay. And there may be witnesses on the 14th too, as well?
Yes, Your Honor.
Okay. All right, so let's make it May 7th for disclosing witnesses, expert reports, and exhibits. We'll see what the state has to do with that, and we'll have a response maybe May 10th. Is that sufficient?
Okay.
It's tight.
Well, that gives us 3 days to respond.
3 days. Yeah, that's right. Well, May 10th is I don't know when I'm going to read all this stuff too, because it's 14th. So if I don't have it by the 10th, then you're saying the 13th. I guess I can do that the night of the 13th. But also, the defense needs some space there too. And I don't think we want to push out that hearing.
So by the way, I know, were you guys like, was there, because I haven't been able, I'm sure, to keep up with every single comment, but were you guys discussing at all the whether or not Cyrus still was working for the defense? Because I know that's a topic that had come up. And I agree, everyone, let's get along. Yeah, for sure. Let's get along for sure. But that is one thing that we have talked about, is if I couldn't find anything to say he wasn't still working for the defense. Again, I say that pro bono. I'm not saying he's getting paid. In other words, I hadn't seen anything that he, quit or was fired or anything like that. I looked for it though.
Yeah, do it by the 10th.
We have no idea what the defense plans on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. We'll deal with it the 13th then.
Yeah, we can try, and then if we
Okay.
need more time, we'll ask for more time.
It's just then on my end, you're looking at, I'm going to have really more, I'm going to need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay,
I don't expect there to be reports.
exhibits.
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay.
New and surprising.
It's hard to have these tight,
I know.
timeframes because
You're not wrong. And that's one of the reasons why it's like, look, he's standing up. Perfect timing, Heather. My God. Yeah. No kidding. Here he comes. Here he comes. There.
we also have other things to do. But Mr. Thompson,
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with
Yeah,
no
this shocked me again. I was like, oh my God, Santa. We only had a yes, sir, and now we're going to get a diatribe. As
idea of what they're going to testify about. The names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last-minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name.
This is wild. This is like unhinged. Wow. Listen to how fast he's talking compared to everybody else. Right? I know. It's yeah, and I totally agree. I agree with this. Yes. People can have different opinions, but yes, treating everybody with kindness is the key thing. And I appreciate that, I'll just say I admire a lot Peter Tragos, lawyer, because he encourages people to disagree and have discussions and stuff like that, because it's important. And, but doing it in a way that is not attacking the person, right? But looking, because that's, it's such a big deal. Like with law, that's a huge part of it. That's the whole point of a trial, right? It's an adversarial system. That's the whole point, right? And if you don't hear the other side, then you don't learn. So, and I always admire that. And, it's not an easy thing to foster. I think he's probably the only channel I know of where they, where the person's like encouraging that. Cause usually, I don't know, it's just, it's a very unique attitude, but I think it's important. And so anyway, but I totally agree. I think it's, and I appreciate that y'all are all on the same page about that as well. Yay.
So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay.
Not fair to the state. Oh my God. You know what, guys? Hold on. Let me back this up a second.
So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay. You don't have to have witnesses or exhibits, but you can have a response.
Oh my God, am I killing
you? Say,
you?
well, this isn't fair, whatever you want to say. Otherwise, I just need to push out this hearing.
The state doesn't have a right to a fair trial. That's the defendant's right. Just saying.
I'm stuck.
I appreciate that, Judge. And
standing back up.
I guess what we've said before, it is more important to do it right than to do it quickly if we have to have a trade-off here. And that includes fairness to everybody involved, including the court. And
really
I prefer.
The argument he's trying to make is, I'm just worried about you, Your Honor, being fair to the court. Because earlier, like I was just making fun of him for, he said the state, because they don't have that right. But here, he's trying to fix it by saying the court. But you know what? He means the state. The court isn't concerned. Dude, this is so odd, right? Like this, it's like he's saying this isn't fair to us, and it's like, what? You're the state? Are you joking me right now?
That this not be kicked off, but we're realizing that we're essentially 2 weeks or less away from these hearings. That apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
Well, let's explore this. I mean, how many witnesses are you expecting to have?
I'm expecting to have 2 on the 16th. At this point in time, I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already. There will probably be 1 or 2 other exhibits, maybe 2 that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be 2 witnesses. On that hearing, 1 for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well.
The PowerPoint. The only PowerPoint I think they end up using is with Leah Larkin, right? Wait, no, hold on. Hold on. No, they don't use any PowerPoints. Hold on. In the hearings on the 23rd or the 30th. I don't think. Yeah, I don't think they use any PowerPoints. But she said if, so maybe they just decided not to use one.
An expert who hasn't written a report.
Yeah,
then we won't offer expert opinion.
Isn't that not for months later, though? I mean, it's all kind of a blur at this juncture, but no, wait. Hold on. That must have been before this, right? Because that's when I decided to cover it. No, I can't. So this hearing is May 2nd, 2024. So I guess Edelman was before that then, wasn't it? Huh. But I know obviously I know there was more than one. So maybe that is what they're talking about. Maybe there's the second time. Yeah, that would make sense. That would make sense if it was the second Edelman one. Yeah.
We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And that's, I mean, it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Yeah.
Thank you.
The PP PTSD is for real happening here. It's PP PTSD.
Well, I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond if you still have that time. That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery.
We got a pop up Santa and a pop back down Santa.
That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff.
That's really funny.
So that we can get ready for the trial.
Well, and Judge, I do for the record need to clarify, the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived. We are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on, instead of being patient and wait because their discovery deadline isn't until September, that we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have.
You know, I feel like it's so rare to see a prosecutor so angry, especially when the defense is being reasonable. Just of recent memory, I could compare it to Mr. Mizrahi in the Shanna Gardner case.
To fight about. Your Honor also noted there are some things that we simply do not have the power to access, and we are trying. We have been trying.
There it is. There it is. It's almost like hiding behind those 3 letters, right? And it's just over and over again. Listen.
On the 14th, and there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access, and we are trying. We have been trying consistently through cooperative efforts as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas duces tecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true.
Utter nonsense.
We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you many of the things that the defendant has tried to itemize, when we talk to our people, they say that doesn't exist. So, you know, I don't know what we're supposed to do at that point.
That was huge over it again, putting my behavior panel hat on. Watch the shoulders here. That's like super exaggerated. It's very unusual.
Many of the things that the defendant has tried to itemize, when we talk to our people, they say that doesn't exist. So,
like a cartoon character.
So, you know, I don't know what we're supposed to do at that point. We'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't. Or no, we'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of them.
Thank you, Your Honor.
Your Honor, I want to respond to that, and I give you particular examples of things. And it's already been ordered to be given to us. The Castro.
So weird. This hearing, again, it's like speed dating. If it were a hearing, it's like I've never seen anything. It's like I forgot about the banner because it's useless. This is just so weird. It's like bam, bam, bam. I've never seen anything like this. There's no format. There's no like order. It's very odd.
Report, which was the draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things, Your Honor. That's
you know what? Let's not go there. I mean, we can sort that out on the 14th. I mean, I read everything. That's what the state was saying. I trust both of you. Okay, your integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful.
I mean,
it doesn't really help me.
He's like, can we be 5-year-olds and not 2-year-olds?
And it started with the last hearing, and I really want you all to just tone it down a little bit.
Yeah.
I mean, you can argue all you want.
I agree, Heather, saying thank you. Yes, it is literally like a skit. It's so insane. Yep. It really is like a skit. It really is. Look at Santa standing there. It's bizarre. This is really weird. I mean, honestly, again, none of their other hearings are like this, but I've never seen a hearing like this on anything. Like literally does remind me of elementary school, right? When you don't know anything about Coeur and you're putting on a skit, and like this is probably what you would come up with, 2-year-olds.
But when it starts to be personal, it's destructive.
It's like bullies on the playground.
I mean, you're really, really good lawyers.
Yep.
So let's just focus on the issues.
And that's just like parents saying to like siblings that if siblings are fighting, like, okay, you're both good kids. We love you all equally. Like, you know what I mean? Like, listen to this. This is crazy. This is just.
But when it starts to be personal, it's destructive. I mean, you're really, really good lawyers. So let's just focus on the issues.
Like if I compliment them, maybe they'll be less mad. I can't.
That's right. We're happy to. And when we get the cash report, we'll disclose it. If we do not have it, we are not withholding. As simple as
I
that.
read that last night.
Trying to get the
Okay.
last word in.
I'm very prepared about what the issues are, okay, about the discovery. And that's why I want to be able to hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of you do the same.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment. There are other issues.
I understand. And I understand your frustration. And
I would
it's a big deal.
I would be wondering, like, is this going to end in a bloodbath?
It's really important. I understand that too, and I acknowledge that. Sometimes, we just can't quite get what we want from other people who might have it that don't want to give it up. So that's one of my challenges on the 14th and probably at the 16th too. Okay. Moving on. We've got all right, some of these pending motions, there was no request or no response from the state. And I'm thinking that the motion to unseal parts of the IGG materials and motion to allow defense investigators to review the IGG materials that we're going to be addressing that on the 16th. Is that?
Yes, sir.
That's the state's understanding. Ms. Taylor?
Yes, Your Honor. Well, we're happy to have a hearing on the 16th for both of those issues as well.
Great. I'm just trying to make sure that we're all on the same page, or at least the same date. But
I just have to quote Dick Arpullian here real quick from Murdoch, singing from the same sheet of music. That's how he would say it.
I wondered, okay, there's been a response on the alibi issue, and I don't know if there is a request for a hearing, or if we just kind of let that lie for now. I don't know. What was your intention there, Mr. Thompson?
I think at some point we're going to need a hearing on it. We're busy enough for the next couple of weeks with these other hearings, so we haven't reached out specifically on that.
Okay.
If the court would like to select a date while we're together today for a hearing, we would be happy to.
Why don't we just wait until the 14th or 16th?
That's fine.
And there may be issues that come out of discovery that have some bearing on that issue. I don't know. You don't have to say anything this day. It can read your mind. Sometimes, maybe not. All right. Okay, I'm going to sign those subpoena deuces taken. The FBI.
The
I
FBI.
think that's related also to the 13th supplemental. Maybe I'm kind of losing track of it.
Your Honor, it does relate to one of our discovery requests, and I'm sure one of the numbered motions to compel. I'll note that when I speak about that on the 14th.
Okay, great. All right. Are there any other issues that we need to address today? Mr. Thompson, Ms. Jennings? Okay, Ms. Taylor?
Yes, Your Honor.
Okay, go ahead.
I want to say this in a way that doesn't come off finger pointing, because it's not. This is about how busy everybody is and how much time it takes to communicate to get hearings set, because there's a lot of people going a lot of directions. I would like the court to consider setting hearings twice a month, every other week. And the court could vacate those hearings if neither party notices something up for that hearing. There would be 14 days notice for either party if we have hearings on that basis. But that way we could notice up specific hearings and just have those set dates so that we're not bugging the prosecutor's office for a stipulation and bugging the clerk's office for a hearing and waiting to find that out. It would speed things up to have 2 times a month that we would know if I've got 14 days before this hearing, I can notice it up and it can be heard by the court. So that's our request, is that the court just reset a couple of hearings. These would not be like the lengthy motions to suppress that we'll probably need a couple of full days for. These would be these shorter motions that we could deal with in 1 to 2 hours.
All right. Thank you. I actually mentioned that, I don't know, one of our hearings, when that's what we need to do. I think it would be more helpful to, I guess, have better communication. Okay. I don't know, maybe you are having good communication with each side.
What is Elf on the Shelf? I'm curious about Elf on the Shelf. But love any participation for any of you guys. Please feel free to share what y'all's holiday traditions are if you have any. And love to hear about those. That's always fun.
It is hard, to get a hearing when the clerk has to contact you or contact Mr. Thompson. This goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases. And I have a lot of jury trials.
That sounds so fun. That sounds so fun. When do they go look for it? Like the next morning? Or that sounds so fun. I don't know how I haven't heard of that. That's amazing though. Oh, that's awesome. I love it. So is it like a daily thing? Yeah, you said you move it every night. So I guess in the morning do they have a certain time period they have to find it by? Are there any rules? Like, can the elf be like anywhere? I'll start asking a lot of questions because I think it's really interesting. Right. You could always be like Sarah Boone and be like, I'm going to go hide in the shower. Sorry. You probably didn't follow that, Stevie, because I know this is like your only case, but but other people might find that funny. Okay, when they get up. That's so fun. I would be so excited. I wouldn't be able to sleep all night. How big is the elf? That sounds like such a fun game, though. See, I would always try to come up with something new. Yeah, that sounds really super fun. I wish I had kids because then I could do that. Right. Thank you, Heather's chiming in with the Sarah Boone, climb in a suitcase. Right. Actually, also another good, put it in a suitcase. Can you put it in a thing? Like, can you put it in like a shoe box, inside another box, inside a box, inside a suitcase? 8 inches. Okay. That's what she said. But also that's small enough that, you could totally, can you put it in like a box of cereal? What else? That's so fun, though. In a glove in a box, right? Yeah, that's super fun. Yeah, I guess if you put it in a cereal or something, it might be nasty, but let us know how it goes. We'll be waiting with bated breath to see how it goes with the elf. So yeah, good night to you though. Have fun with that. I find everything wrong with Richard Allen personally. I don't know anyone who doesn't.
Going from here really to the end of the year. So it's hard for me to say, okay, we're going to have it. I think I offered Thursday, like a Thursday afternoon. So I'm willing to do that.
One thing that's
I
funny,
might-
we've still been sticking with the Thursday schedule, even with Judge Hippler.
Is set like once a month, maybe. And then if you need something more, just let us know. But I'll look at my calendar and set that up. I mean, I know you come down on Thursdays generally. So that's a good day for you, right?
Thursdays are fine, Tuesdays are fine, Fridays are fine. Wednesdays are rough, but whatever day works for the court, I'll make that work. I just think it's more important that we have a place to put these hearings so that everybody's not spending a lot of time asking each other what day's okay, what time's okay, that we just all know that this is the time. So whatever day works best with the court schedule, Your Honor, is just fine with me.
Thursday afternoon is probably
That'll work.
Monday is impossible. So what do you think about that, Ms. Jennings?
Yeah, that makes sense. I think Thursday afternoon would be fine for the state.
Do you think twice a month? It's probably going to ramp up.
I suggested that just because then there's 14 days to the next hearing, so everybody would always have enough notice. This is why I suggested that, and to know that we have those to iron out issues that are going to arise. Again, these aren't for the motions to suppress; those will come later.
Maybe we'll start with
Press motions do something.
twice a month to get through all this discovery. I mean, I hope we can all get past that soon. And move forward a little faster. Okay, anything else then?
No, thank you.
Okay. Okay, great. Well, thank you all and have a good day. Beautiful day.
A beautiful day. Okay, I'm gonna play something for you guys because a lot of you guys probably haven't seen this. For anyone who followed Karen Reed, I think some of you guys might find this funny. If you don't, that's okay. But I just, because I don't know, for whatever reason, I feel like I'm in the mood. So this is during Karen Reed. So this is like a music video, if you will, kind of, that I made. So Get Low Canton Style. So like this is Get Low from like the early 2000s, but it's like Canton Style. And so it's supposed to be funny. Just let me throw that out there. It's supposed to be funny. Do 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 do. 339 Canton time. Jackson United, it's time to shine. There's snow, there's snow, there's snow, there's snow. To the window, to the wall, to the wall, to the bartender's last call. At the waterfall. I say sleep, motherfucker. I say sleep, goddamn. I say sleep, motherfucker. I say sleep, goddamn. They all crunk and act and mean. Brian simply rest when they have too much drink in their minds. Everything's fine, but an act have already gathered about 50 damn times. To the window, to the wall, to the wall. The bartender's last call. At the waterfall. I say sleep, motherfucker. I say sleep, goddamn, goddamn. I say sleep, motherfucker. I say sleep, goddamn. Do 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 do. By the way, all of everything's from the trial. The wall pictures are literally from the Alberts' house. And then all of the snowplow pictures and stuff are local Canton snowplow companies that still operate and probably were operating. So like everything is all legit, whatnot. That's my voice. That is my voice. Yep, I have seen it. Definitely saw that. Yep. I know. It was, dude, that woman's afraid for her life. It's insane. Yeah, definitely saw that. And she came on, I don't know if you saw it, but they also, both of them came on Court TV with Vinny. And Vinny was like, dude, his reaction was like wild. I've never seen anything like it. He was like, I gotta take a minute. And I don't know, it was pretty crazy. Yeah, I've seen that. So I mean, you know, you could be right, but he does a really good job of acting surprised. I will say. Oh, you saw the one thing. Yeah. So, you know, they have like a 3-hour long video or whatever, before that happened on, Defense Diaries, with her. And, so I saw both of them, but, listened. I was raking my leaves in my front yard and listening to the long one on Defense Diaries because, yeah. I mean, you could be right, but I will say I love Vinny. I don't care what anybody says. I love Vinny because of his enthusiasm. I love his enthusiasm. But yes, so you got this one.
That call is actually from Brian Higgins to you, isn't it?
Yes.
Obviously, you know how long 22 seconds is.
What's that?
You know how long 22 seconds lasts?
Yes.
So much goodness from that whole thing. So anyway, guys, that is it for this one though. So tomorrow we got Alex Murdoch. I might have something else tomorrow too. We'll see. Next thing up for Shannon Gardner is going to be all the death penalty motions. And yeah, so we will definitely have other things happening, but yes. Yeah, it's so funny because I feel like I'm one of the only people. I don't really know anything about Gray Hughes. I mean, I've heard of the name, but that's pretty much it. Other than that, yeah, I don't have any. If you saw the tree in my front yard and the leaves, it is not for the faint of heart, I will say. It's a force. It's unlike anything. And I love the huge tree because guess what? I have all the squirrels and I also have the red foxes. I also have a falcon that comes to my backyard regularly. It's like a magical, like forest situation. But the trade-off is I have all of the leaves and it is, insane. But I've got them almost halfway up the hill in the front. So I've got an owl too. Actually, the other day I was out in the front yard with my dog Frodo, who's like 15 pounds, and he looks like a little red fox. And an owl tried to freaking come and snatch him up, that was a first. The owl literally, I was standing there with him. It was freezing cold. The owl like swooped down. It scared the shit out of me because of course it was pitch dark. And I was like, what the fuck? And he like tried to swoop down and get my dog. And then he went and perched and literally Frodo was like peeing, you know, and he was like, had eyes. I was like, oh my God. And he was like staring at him. I was like, that's what I've never experienced that before. That's first. You have black squirrel with orange tails. Are you in, well, you don't have to say where you are. In the up north, that I've seen that up north and heard that up north. That's really funny. But it's really funny too, because you guys probably haven't heard my bear story, but I have a bear story. Maybe someday I'll tell you guys. But oh wow. Huh. Yeah, I had a bear encounter and in the city. Weirdness. But that owl, that was something. It was huge too, man. But black squirrels with orange tails. I mean, I have seen the black squirrels, but not the ones with the orange tails. That's pretty crazy. But, you know, we love all the squirrels here. So So anyway, guys, that's it for this one. Thanks, guys, for being here. What is a zombie deer? That sounds terrible. But yes, thanks so much for being here, guys. Hopefully I'll see you guys on the next one. Thanks for all of y'all's help and sharing information, documents, and for being awesome and encouraging discussion and agreeing to disagree and whatnot. But yes, other than that, that is it for this one. And I'll see you guys next time.